Well, good morning, everybody. Welcome, welcome. Not so terribly early today, getting a late start over there in Fairfax County. As we're waiting for the final pretrial conference in Karen Reed's case before we are expected to start the trial on April 1st. Now, I say expected because things have been super up in the air. A lot of hit and miss, last minute stuff, not quite sure what's going to happen. There is still a motion to stay the trial that's pending before the First Circuit Court of Appeals. That is Karen Reed's motion to basically ask that the court be required to hold off until her appeal that raises double jeopardy issues can be decided. I have talked about this motion before. I don't expect it's going to be granted, but it certainly isn't impossible. And so that is a pretty critical question that we need to know one way or the other before we know for sure whether April 1st is going to be go time. We also had the suggestion from Judge Cannone last week that they might just kind of take this middle road, play it by ear, start on April 1st with picking the jury, but not actually swear the jury and start the trial maybe until later. I don't know. I guess that's possible too. We're just going to have to kind of wait and see how that goes. My suspicion, however, is that if we don't get a stay from one of the federal courts, we are unlikely to get one from Judge Cannone. But we'll see. I mean, strange things have happened in this case. So we did get some new documents this morning that I'm going to go ahead and share with you guys. Oops, that's not working very well, is it? We got their formal written opposition to the motion in limine to exclude the third-party culprit defense. So this is some pretty good stuff. What I really like about it, we'll go ahead and go through it real quickly, not spend a ton of time on it. But what I really like about it is that it really spells out what their case is against each of the individuals that they've named. And this is just good activity to be involved in at this point in the trial preparation because they're getting ready to tell their story. And so this is like kind of like a dress rehearsal. You know, this is the story that you're going to tell about these people and the evidence that's going to come out. It's, you know, good to have a test run and see how that lands. So ultimately, they are, of course, arguing they should be able to present it. It does meet admissibility standards. She has a constitutional right to present a defense. Contrary to the Commonwealth suggestion, they don't have to name a single person or prove that the person committed all of the offenses the way that they're charged. And even if she was not entitled to introduce this evidence, it still meets the standards of admissibility for Bowden, and so can establish the inadequacy of the police investigation. And that's really where the defense last week indicated they were leaning anyway. And personally, I tend to think that is a good idea. So this is the part I really like, where they lay out the relevant facts regarding the third-party culprits. Nail it down. Fact, 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 fact. You know in the back of your head what evidence you have that you can present to establish each one of these things. And it's just a way of organizing it and laying it out in a way that a jury would be able to follow and understand. So Brian Albert did not have a good reputation among his fellow police officers. He was known as a bully, someone who has a history of sucker punching fellow officers, particularly when he was drinking. This is news to me. We didn't hear that at the first trial. He has been investigated by Boston Police Department's Internal Affairs Division for his violent conduct in that regard. Also not a great fact. Albert is a trained boxer, and several of his fellow officers were afraid of him. Brian Albert was present at the scene of John O'Keefe's death on January 29th, 2022. John O'Keefe's lifeless body was found on Brian Albert's front lawn, just feet from his front door and the door to his garage. Brian Albert admits to having been home at all relevant times. The evidence, including computer forensic data, this also sounds new, overwhelmingly establishes that John O'Keefe entered Brian Albert's house. I say this sounds new because I remember hearing about John's laptop, but not a ton about it. Just that he had his desktop, he had his laptop, they were password protected. No evidence that Karen was able to get into his computer because that had been part of the argument that, she went in and deleted the Ring camera footage. But they were never able to show that she had access to that computer. That's the only computer forensic data that I personally remember. So have they gone more into John's phone? Like, the thing is, when you have an Apple computer and you have an Apple device like an iPhone, you probably got a lot of syncing up of things. So I wonder if they've got more data out of his computer. Maybe somebody else's computer. I don't know, but I'm intrigued by this because we heard a ton about cell phone data. We've certainly anticipated that there's going to be more data from the cars, Karen's SUV's entertainment system, the infotainment system. Hint from Mr. Brennan last week about Wi-Fi connections, the time that John O'Keefe's phone disconnected from Karen's Wi-Fi at about 12:30 in the morning. So, a little hint here of perhaps something that is still to come. Brian Albert was drinking heavily throughout the day and night in question. Brian Albert spent the day and night with Brian Higgins. In the weeks leading up to John O'Keefe's death, Brian Higgins had demonstrated a romantic interest in Ms. Reed, Mr. O'Keefe's girlfriend, but he had been rebuffed, essentially ghosted. And on this night, Higgins was confronted with Mr. O'Keefe and Ms. Reed together and clearly happy. Higgins's words and deeds revealed significant aggravation. Brian Higgins was in Brian Albert's home when John O'Keefe arrived. After a period of time, Brian Higgins left the Albert residence but maintained contact with Brian Albert. There were suspicious and unexplained phone calls between the two of them at 2:22 a.m. on January 29th, 2022, not long after Mr. O'Keefe was mortally attacked. Mr. O'Keefe had injuries and wounds on his right arm from an animal or dog attack. Brian Albert had a large German Shepherd at the location on the night of the attack, a German Shepherd which indisputably had a history of violent dog and human attacks in the past. This aggressive and violent German Shepherd was, according to Brian Albert, not good with strangers. None of this evidence was investigated by the police in charge of the case. In fact, the evidence shows this was by design. Ex-trooper, I use that too. Ex-trooper Michael Proctor was asked in a text exchange whether the homeowner Brian Albert would catch grief as a result of having a dead body of a police officer on his front yard. Michael Proctor's response demonstrated his intent to protect a fellow police officer. Nope, the homeowner is a Boston cop too, verifying his intent to give a pass to Brian Albert. There is also consciousness of guilt evidence implicating Brian Albert. Consciousness of guilt evidence. A lot of folks have been asking about that because, of course, they're trying to bring it up with Karen Reed and the Turtle Boy stuff. Like, is this just a one-way street? Oh, no. The defense is using this as well. They're using it against a lot of these parties. So despite a massive police presence on his front yard, just a few feet from his bedroom window, Brian Albert never came out of the house to speak or interact with other first responders. It is worth noting that Brian Albert was at all times a first responder himself, yet he chose to ignore his duty to help someone in need in favor of remaining secure in his home, away from those who might question him or his family. Further, after John O'Keefe's death and after the defense publicly raised the specter of a German Shepherd attack in open court, Brian Albert's German Shepherd was rehomed. Brian Albert essentially jettisoned a longtime member of his family to another state, out of the reach of investigators, out of the reach of defense. Any reasonable investigation would have seized upon the combination of this suspicious conduct in furtherance of a fulsome investigation into the death of John O'Keefe. It's pretty powerful. Pretty powerful description of Brian Albert's role. So let's go to Brian Higgins now. Like Brian Albert, Brian Higgins was at the scene of the crime on the night in question. Brian Higgins was at Brian Albert's house at the same time that John O'Keefe arrived and went into the house. Brian Higgins had been engaged in a flirtatious text message exchange with Ms. Reed in the weeks leading up to January 29, 2022. He had testified that Ms. Reed had kissed him after he watched an NFL playoff game with her and others not long before January 29th. He testified that Ms. Reed visited him at his apartment after that. But Higgins acknowledged that the text message flirtation and all contact between them ended, and that Ms. Reed was the one to end it. She stopped responding to him. She no longer gave him any attention. Ooh, that stings. This was after Higgins indicated in multiple text messages that he was interested in her and found her attractive. Yeah, Higgins fumbled that one hard. On January 28, 2022, Brian Higgins was confronted with Ms. Reed and Mr. O'Keefe walking into a bar together, getting along, and in the words of at least one witness, acting lovey-dovey. Ms. Reed and Mr. O'Keefe were affectionate with each other that night. Brian Higgins was there with Brian Albert watching it. Higgins's annoyance and irritation were reflected in a sarcastic text he sent to her while she and John were merely feet away from him. Well... So passive aggressive, not attractive, dude. That's not game. There is evidence that Mr. Higgins wanted to lure Mr. O'Keefe to the Albert residence. At the waterfall minutes before he leaves, Higgins motions to Mr. O'Keefe, then follows up with a text message to make sure he would be going there. This did not get emphasized in the first trial, and it's gotten a lot of attention since then. It came up in the interview that Dr. Turtleboy did with Ronnie the juror, and asked very specifically about that. Ronnie said, nope, they really didn't notice that. The jury didn't notice that when they were looking at those videos from the waterfall. So important to call that out and point that out, highlight it if it's part of your theory of how the case went down. Clearly, they're on it now. Higgins went inside Brian Albert's home. John O'Keefe also went inside. There is evidence, therefore, that Higgins had the motive, intent, and opportunity to cause harm to John O'Keefe. Like with Brian Albert, there is also evidence of Higgins's consciousness of guilt. For example, after a long day of drinking and driving, Higgins did not go home after he left the Albert residence that night. Instead, he went to the Canton police station. He initially claimed that he went there to do some administrative work, but later changed his story to going there to move his vehicle. I love using the police's own techniques against them. Very common one. He changed the story. You deviate one iota from the previous version of events that you gave. Even honestly, if you're just fleshing it out and giving more detail and so forth, the police will turn that into he changed his story. So I love seeing the tables turn on that kind of approach. He was consistent, however, about the fact that he never called anyone on the phone while there. That turned out to be false. Video evidence undisclosed to the defense during the first trial establishes that Higgins made a phone call while he was at the Canton police station at 1:40 a.m. He has not revealed who he called. Given that the evidence was not timely disclosed, the defense did not have an opportunity to confront Higgins about that fact. I wonder who he's going to say it was. Right? I tried to call my mom. She didn't answer. Yeah. Who's it going to be? Who are you calling at 1:40 in the morning? When Higgins went home after that, he still did not go to sleep right away. Maybe he's checking his emails, checking his voicemail. Yeah, who knows? At 2:22 a.m., he speaks by phone with Brian Albert. He tried to claim that the phone records a but dial and apparently a but answer, taking Albert and Higgins's testimony together. This 22-second phone call, however, is further evidence of consciousness of guilt. When Higgins, and it's the explanation for it that's consciousness of guilt. The fact that you can't acknowledge having this conversation with Brian Albert, you have to, the phone records are wrong. There wasn't an actual 22-second connection. It's just a butt dial, and no explanation for that. That to me is the real consciousness of guilt part. Less the phone call, more the explanation for it. It's never the crime. It's always the cover up. When Higgins realized that the defense was interested in seeing the contents of his phone, a defense motion had been filed, he further demonstrated consciousness of guilt, yes, he did, by getting rid of his phone and his SIM card. The manner in which he disposed of it, however, was extraordinary and showed how intent he was on keeping the information from his phone out of the hands of the defense. He destroyed the SIM card and then traveled to a military base to put that tiny object, about the size of a thumbnail, into a large dumpster. Higgins's conduct on the night in question and following established clear evidence that should have been investigated during the course of this investigation, but which evidence was ignored by Michael Proctor and his supervisors. Last up, Colin Albert. Colin Albert had been in a feud with John O'Keefe in the weeks and months leading up to January 29th, 2022. Colin had thrown beer cans in Mr. O'Keefe's bushes and told Mr. O'Keefe to F off to his face. I'll bet that's not what he said, but we're being graceful here in this pleading. Colin Albert testified under oath that he had never been in a fight in his life, yet there was video evidence of him taunting others to fight, desperate for violence. Bang, 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 bang. Pull up, bitch. There was, and then we even saw online what are at least purporting to be some fight videos that Colin is involved in, and I gotta tell you, he's not good. Kiddo ain't good. Needs to put in some work at the gym. Colin Albert, after John O'Keefe's death, was photographed with his knuckles scraped, consistent with injuries that would be suffered during a physical altercation. Colin Albert's name was purposely omitted from the police reports. There was no indication in any of the reports provided to the defense in the first months of this investigation that Colin Albert was anywhere near 34 Fairview Road, his uncle's house, on January 29, 2022. In fact, there was no indication in those police reports that Colin Albert even existed. It was not until the defense sent a letter to the prosecution while the case was pending before a grand jury, notifying the Commonwealth that Colin Albert should be called as a witness, that the Commonwealth finally produced information that Colin Albert was indeed present at Brian Albert's home on the night in question. It is a reasonable inference from the evidence finally and perhaps grudgingly provided to the defense that Colin Albert's name was intentionally omitted from the police reports in order to protect him. Similarly, Brian Albert is the only person listed in the initial report whose first name was not spelled out. He is just listed as B. Albert, and the number of his home is misstated on various first responder reports. These myriad mistakes are more than simply curious. They are systemic in this investigation. They appear to be a conscious effort of the investigators of this case to hide these third-party culprits from the defense and the public. So that's the facts of the third-party culprit motion, guys, and I found that to be quite a compelling story. Now, it doesn't have everything in it. A big standout piece that I noticed that's missing is the evidence having to do with when Colin left and how they're trying to piece that together. The text with Allie to ask for the ride, and then how that tied in with Allie's data from whatever that app was that you spy on your kids. You know, you track your kids' location and stuff. You'll remind me in the chat, I'm sure. I can't remember the name of it off the top of my head because we don't do that in my house. My husband can go where he wants. It's fine. We trust each other. Imagine that. No, I know kids are different. Life 360. Yes, thank you. Thank you very much, Red. Where did it go? It's already gone. Red Pentrometer, Life 360. Penetrometer. Nice one. So, They left some of those details out. I don't know if that's by design or if they overlooked it, but if it is by design, I have to say I approve. I generally approve. And the reason why is because they've already had an opportunity to try out their case once. And so now is their chance to edit. You got to edit One of the things that Ronnie mentioned in that interview was how difficult it was to keep track of all the different pieces of evidence. The jury doesn't know as they're going along what's going to be important and what isn't. And so that's part of your job as the attorney. Simplify it, edit, lay it out for them in your opening, elicit it during the examination, and then remind them of all of that in the closing. And it's just going to be much, much easier for the jury to be able to follow along and understand where you're going. But part of that editing process means you don't put everything under the sun out there. It becomes too much. It becomes overwhelming. It becomes too convoluted. Looks like we might be getting started over there in Fairfax. They're there in court, so I'll go ahead and bring it up. Not hearing any noise yet, although they are standing and making their appearances. Let's get going, Court TV. So, bottom line, you have to always cut stuff that may not be critical to the point that you're trying to make. Can we please have some sound, Court TV? How about some sound? Is there maybe another channel that's going? Oh, why do we always have this annoyance? Hearing law and crime. Let's see if I can get it. And we'll just start over there. Let me get us out of here. And shut it up. Okay. Give me just a second here, guys, so I can get this going. That looks like this is not today's hearing. Here is today's hearing. Back to the beginning. Okay. I think we are ready to roll. So let's go ahead and get it up.
All right, so before we begin, Mr. Jackson, when we left the other day when we were talking about Michael Easter, I gave you the opportunity to get some authority on expert testimony and voter defense. Were you able to do that?
We were.
Do you have something to file?
Yes, it was filed yesterday. I do have a courtesy copy of the court.
Okay.
And I can, if the court wishes, we can take that on. That's suffice.
I think so. I'll take a look at it.
It's got everything in it that I would say orally. Anyway, if the court has any questions, I'm happy to answer the questions.
All right.
Okay, so they are filing something with
Thank you.
the expert testimony. Just haven't seen that yet.
So, thank you. So, similarly, regarding the third-party culprit argument the other day, Ms. Yanetti, I see you did file something late yesterday, so I got that. I'm just wondering if either the Commonwealth or the defendant want to be heard on that.
The Commonwealth does.
Okay, so I'll hear you, Mr. Brennan.
Terrible audio from the court today. Let me see if I can adjust it at all.
Your Honor asked for a proffer from the defense regarding third-party culprit. Alternatively, evidence that would be separate regarding third-party culprit aspect of Bowden. We received some information from the defense that does not distinguish whether their intention is that it applies to third-party culprit or whether it applies to a third-party culprit aspect of Bowden. Those concepts are logically and legally distinct. Regardless, when you look at the proffer by the defense, it is insufficient and inadequate for both third-party culprit and for any third-party culprit aspect of Bowden. Two different analyses, but the evidence is equally feeble for both. Relative to third-party culprit evidence, there are a number of cases that I know Your Honor is aware of that guide.
All right, guys. The sound's awful. We are going to switch it over to NBC 10, and we will start over with whatever Mr. Brennan is saying here.
Alternatively, evidence that would be separate regarding third-party culprit aspect of Bowden. We received some information from the defense that does not distinguish whether their intention is that it applies to third-party culprit or whether it applies to a third-party culprit aspect of Bowden. Those concepts are logically and legally distinct. Regardless, when you look at the proffer by the defense, it is insufficient and inadequate for both third-party culprit and for any third-party culprit aspect of Bowden. Two different analyses, but the evidence is equally feeble for both. Relative to third-party culprit evidence, there are a number of cases that I know Your Honor is aware of that guide the standard of third-party culprit evidence. Not to iterate the law because it is clear, but there must be relevance, there must be a substantial nexus between the claims of the defense and the third-party culprit theory. They provided us 3 people that they identify as third-party culprits. It's helpful just for a quick synopsis of the history. In this case, prior to the first trial, the defense never identified a third-party culprit. At some point, the defendant herself said that they knew who the third-party culprit was, and recently, the position of the defense has shifted that they don't know and don't need to know.
Well, it's true, they don't.
Now, the law accommodates specifically identifying somebody. It also accommodates general, but it has to have specificity in the complaint. There has to be a motive, an opportunity, and an intention. There has to be evidence that draws the correlation. It can't be bad character, speculative, or just putting out information that's negative towards a witness so that that can backdoor prior bad acts against a witness and be used for a different purpose.
To you, Mr. Brennan.
They identified one person, Colin Albert. And in their proffer, what they offer, number one, and it's important to take them separately because it shows how feeble it actually is. The first thing they say about Colin Albert is he had a feud with John O'Keefe in the weeks and months leading up to January 29, 2022. Now, other than maybe on social media or in interviews with the defendant and national broadcasts, there's no evidence of that. There was no evidence that's going to be admitted at this trial that shows there was a feud between Colin Albert and John O'Keefe. There is no evidence that there was any hostility between Colin Albert
they testified
and John
to it.
O'Keefe. There's no evidence of a motive to kill John O'Keefe by Colin Albert. There is no evidence
from the
of
circumstances.
any motive, of any intention, or of any opportunity whatsoever. In fact, the evidence is that Colin Albert was not even at 34 Fairview at the time John O'Keefe arrived there on January 29, 2022. And so simply saying it is not evidence. And an attorney should not be allowed to confront a witness about an allegation that has no factual basis for them to then have to defend the accusation. The prejudice then seeps to the jury, and the Commonwealth is in the position of having to disprove a claim that had no basis to begin with. The second claim that they make regarding Colin Albert is that he had thrown beer cans in Mr. O'Keefe's bushes and told Mr. O'Keefe to F off in his face. There is no basis for those claims. There is no witness for those claims. There's no information regarding those claims. I understand there may have been a party where there was beer cans, but there was no Colin Albert. So to attribute a situation or an incident to him, the defense would need some good faith proof, actual proof, fact, that this actually happened. And there's no evidence whatsoever that Colin Albert threw beer cans in Mr. O'Keefe's bushes and told him to F off. And the reason there's no proof is because it didn't happen. So again, the defense asks for an invitation to simply cross-examine a witness, allege a prior bad act, and then the witness has to defend their honor and the government has to disprove it. That is not the cloth that third-party culprit is made from. Regarding the suggestion that there was some type of feud or tough relationship, I saw on a video that there were two radio personalities, and I have the clip, who spoke and met with Karen Reed. And during the conversations, at least they relate that there was some claims about a drug issue. And according, not to the defendant, but according to the interviewers who supposedly interviewed her, they said that the story is completely false. They attribute this to Karen Reed. People are trying to make it more dramatic, like Colin would have a reason to hate John O'Keefe. That never happened, referring to some drug claim. He did not report him for anything. And so what we know is there is no history of animosity between Colin Albert.
Well, funny how
and
they
John
didn't even
O'Keefe.
mention that in their
We
memo.
know that there was no animosity between his family
raising
and John O'Keefe.
Colin
The
maybe
only
have
event known is that at some point, Colin Albert's younger brother ran across John's lawn. Mr. O'Keefe supposedly yelled at him and then bought him candy as an apology. That's it. So we have an alleged third-party culprit, a very strong claim, with no evidence, no motive, no opportunity, not even present at the time that this alleged collision occurred. And so in that absence of evidence, it's not even feasible. Colin Albert should not be brought to the stand, attacked with acts that didn't occur, that otherwise would have no admissibility. Really, it seemed to be a backdoor way to tarnish his reputation and then bind him with other people the defense would like to attack, to make a general suggestion that somehow this group of people are bad people. I know at the last trial, there was pictures of Colin Albert's knuckles that were scraped, and inevitably it turns out that picture, I think the exhibits were introduced at trial, was taken much later. Pictures taken before that point show that Colin Albert's knuckles on the 9th and 11th of February weren't scraped at all. So because he had scraped knuckles, subsequently, because he may have done a video that some use would maybe do and threaten somebody else, not John O'Keefe, has nothing to do with this case whatsoever. It's an attempt to introduce
bang, bang
aggression
video.
or prior bad acts, but there's no bind
He
whatsoever.
made scrapey knuckles for
The
the bang,
second
bang
person
video.
that the defense would like to identify as a third-party culprit is Brian Albert. And this is some of the gross generalizations that you see with Colin Albert. No specificity, but trying to assault his general character by generally suggesting things that may or may not be accurate in just telling part of a story. They claim he didn't have a good reputation among fellow police officers. No evidence. They claim it, and even if it was so, has nothing to do with this case. Known as a bully, so rumor clearly is not admissible in a criminal case. Had a history of sucker punching officers. We don't see any specificity. We don't see any evidence. We don't see any information. We just see a general attempt at a character assassination to portray him as somebody who is either capable or a bully. Nothing relative to John O'Keefe.
On the stand to establish that? Because what they're telling you is they can.
They suggest, and I'm not sure what the basis for this is, that he was drinking heavily that day when he went to a funeral with Mr. Higgins and another person. It is true that he was at the hillside around 9 o'clock and was drinking around 9 o'clock. So all of this information is just general inflammatory accusations about character. They say he was a trained boxer because when he worked out, he boxed and he was engaged in charity events, some dating back to 2003. By that standard, anybody in the neighborhood who has any self-defense training, mixed martial arts, or boxer would be on the target list. The fact that he is a police officer and that he is physically fit and that he trained to protect himself doesn't make him a third-party culprit. It is this general suggestion of strength and distorted into a hopefully perceived sense of violence that it has no root at all, no root. They went as far to say he was investigated by BPD for violent conduct, but they don't give any details. If they looked, they could go online, they could investigate potentially there is no sustained findings that are known to the Commonwealth against Brian Albert in internal affairs, none whatsoever, ever. And so to make the suggestion he was investigated by BPD for violent conduct, they provide no fact. I'll say, even though it is off base entirely, it has nothing to do with John O'Keefe. They're trying to suggest that he has a propensity for violence. And they don't do it very well because they provide no details. These are all just general accusations by the defense. In fact, I would say it's not important or admissible. You can't bolster the good character of a witness, but to simply make suggestions of bad character is not any root or tethering
He's
to
such
this
a
case
good guy.
specifically.
He teaches the kids boxing.
Instead of bad character,
He goes to all the
Brian
funerals
Albert
of the fallen police
is a two-time
officers.
recipient of the George Hanner Award,
Yeah,
has
here you
many,
go. Go
many
ahead and
medals
do
of
it.
honor from the Boston Police Department, but that is not the issue. They suggest that he was involved. So they know that they have to tie him not only to the scene, but somehow to Mr. O'Keefe. And other than being at the bar that night and Mr. O'Keefe and Miss Reed pulling in front of his property that night, there is no association between the two.
Higgins being
They
his
say
best
he's present
bud.
at the scene of death.
Higgins being the one with the
By
motive.
all evidence,
Him
Mr.
having the
O'Keefe
interest
died
in
feet from the street near the flagpole in front of 34
the fact
Fairview.
that it's his
So
house.
that's a little bit broad. He wasn't present at the scene of the death. He wasn't there. That happened out front on the front yard near the flagpole, about 70 feet from his house. The body was found feet from his front door, arguably, okay, 70 feet, 75 feet. He admits to being home. He doesn't have to admit he was home. Now, here is another claim without any evidence whatsoever. The defense states emphatically, computer forensic data overwhelmingly establishes O'Keefe entered Albert's house. I
Yeah,
haven't seen that evidence.
I haven't seen
Based
it
on
either.
law. So if they're
Not
going to
even
make an
green.
offer of proof to the court and they're going to make claims to substantiate this theory, they have to have proof of it. And in their motion, I see no proof whatsoever
That's because this is an
that
offer of
overwhelmingly
proof.
establishes John O'Keefe went into the Albert house. In fact, what we see is the opposite.
Why do I suspect Alessi
In the
will
past
have to
trial,
look up and say,
numerous
here's
people were
exactly
involved.
how we're going to
Every single
substantiate all of
person.
these factual allegations.
That was asked, stated they did not see John O'Keefe enter that home. Every single person. Now, whether you believe it or not is irrelevant. What's relevant is there's nothing to the opposite. There's an absence of
There's a
evidence
lot
to
to
the
the
opposite.
opposite, and it's circumstantial
In fact,
and
the
it's
phone
inferential.
data and the Waze data and the GPS and all the data puts John O'Keefe at the front yard, not in the house. So
There's
if
that
they're
problem
asking
with
the
stairs,
court
though, isn't there, Mr. Brennan?
to make a finding
Not
of
just like
substantial
stairs
link and
in the yard,
substantial
are there?
proof that John O'Keefe was in the house, they have to actually give you the facts and the science and the data to support that. And I don't expect that will happen. They add that there was going to be expert testimony that the scratch on John O'Keefe's arm was from an animal or a large dog. And because Brian Albert had a dog in the house, there was some type of inference. Dr. Russell has already testified at the Lanigan hearing that she's not saying that those bite marks were from Chloe. Although it has not been
Correct.
decided by the court,
That's the
Dr. Crosby has
inference.
done molds that show that the
Called an
teeth
inference.
comparison is totally an opposite. And so even the defense is not saying, as I see from the
It was a
disclosures, that
different large
Chloe
dog.
bit
It was
John
visiting.
O'Keefe. Their version, which we don't agree with, is that a large animal or a dog caused these wounds. They don't say where, they don't say when, they don't say how. And so that is not a link so that Brian Albert becomes a third-party culprit. Finally, in a way to try to create some type of traction against Brian Albert, they associate him with Brian Higgins because they spent the day together, because Brian Higgins, according to them, was rebuffed because of phone calls at night. All of these general claims with no fact predicate rely on innuendo, surmise, speculation, or just the creation of an inference that does not exist.
It
There is
does
no
exist,
evidence Brian
Mr.
Albert
Brennan.
had
You just don't
any
like it.
motive
That's called
whatsoever
circumstantial
to harm
evidence.
John O'Keefe. None. There is not one witness
And you're happy
There's
to
not
use
one
it if it
statement
benefits your position, aren't you?
that Brian Albert had any animus whatsoever towards John O'Keefe. None. He did not have the motive. He did not have the
Karen hit
opportunity.
him with the car.
And there was no evidence that he was involved in any way in the alleged collision that happened in front of his yard that night. Finally, the defense turned to Mr. Higgins. Mr. Higgins was at the Albert address that night. John O'Keefe never went into the Albert address that night. They take very, very select pieces of information, and I would suggest don't tell the whole story. And from that, they want us to speculate a motive. For example, they say that Karen Reed had kissed Mr. Higgins at John's house.
Well, John,
That seems to be
Brian said
corroborated in the text messages. According to the text messages, Mr. Higgins essentially says that Miss Reed came up to him and planted a kiss on him. And there's quite a bit of text message exchange that you heard during trial about that interaction. And then at some point, Miss Reed went to Mr. Higgins' house. And so there was some interest, it would appear, from the text messages between the two. Mutual, at best. There's a plethora of text messages where Miss Reed is pursuing Mr. Higgins, looking for his time, looking for his intention.
We remember, Mr. Brennan.
And one she says,
and then
basically begging him to come over.
Because he had no
Do you
game.
like me? Come over to my house.
We remember
There
very
are text messages talking about Mr. Higgins not having enough time for her. So there is a flirtatious relationship between the two of them. What we don't see is that somehow that creates a motive for Mr. Higgins to want to hurt or kill John O'Keefe. The fact that they are texting together and later that night he sends a text message because I think an inference the defense would raise is that he felt like he was ignored or wanted to know what was going on with their relationship, is not evidence of motive. In all of these text messages, you never see any animosity towards John O'Keefe. Mr. Higgins's text messages
kind of see some animosity in that video at Waterfall, don't we?
Towards John O'Keefe. It's uncomfortable. It's an awkward situation because both of them appear to be deceptive as it relates to John O'Keefe, but there is no vengeance, there is no anger. And so the suggestion that there is a motive because there was flirtatious text messages to then kill the man is beyond the pale. It's beyond any logical connection.
Well, is it better than because they were in Aruba a month ago and argued about John kissing someone else?
John O'Keefe asked him if he was coming to the home that
ridiculous theories of motive.
He lured them to the house. I mean, we do
What's your
look at this
theory
evidence
of
not
motive?
vacuum,
He was
but
going to break up with her? You think that's
not
better?
knowing that Karen Reed was not going to come in when they arrived at the house. Is it reasonable? Is it rational? Is it lucid to think that that Mr. Higgins was inviting them both over to the house, not knowing only one of them will get out of the car? Is the suggestion that Mr. Higgins was going to kill both of them? Or he was going to kill one of them, so the other one he would then set up for murder so that he wouldn't be able to see her anyways.
You
The
dumbass.
absurdity of the relationship between the claim
They were
and
gonna
reality
fight.
is so great that it will just run rampant through this trial. It will be unrelated, speculative, shotgun approach to claims that the witness will spend their time trying to explain and defend. It will distract the jury, and it will serve the purpose, which the case law says it shouldn't, of taking attention off the facts at issue for the case we're here from. And that attempt to divert anybody but the defendant is the attempt here. That's why we have three, we don't know who, but three potential third-party culprit evidences.
Don't look over here to see here. But the fact is, there's a lot there.
What they offer is they believe Mr. Higgins lied because he went to the Canton Police Department to do administrative work. And I think the evidence is clear that he had cars that he parked there as part of his job that he needed to clean off. So they are parsing words in an attempt to create a basis that doesn't exist. that there are calls between Mr. Albert and Mr. Higgins later that night. So what? They have no evidence
They denied them.
that either of them spoke to each other. They have no evidence
Yeah, they do.
of conversations.
They
They
have
have no
phone record of a
evidence of a
22-second
conspiracy. They
call.
have no evidence of a cover-up. They have no
Yeah, they
evidence of a
do.
weapon.
That's it right there. That's why you got to
What
say
we
no
know is
evidence.
John
You have
O'Keefe
no
never
other
went in the
response to
home.
that.
And so to try to create this image based on obscure facts is not the substance that's required under third-party culprit. I know third-party culprit is a time-honored tradition and is a broad latitude, but it's not endless. It can't prejudice the Commonwealth. It can't distract the jury. It can't be based on fiction. It has to be based on an identifiable theory. The cases that have allowed third-party culprit that have been reported have actual people who could be a third-party culprit, who actually have relationships
Yeah,
to
we
the
have
scene
actual
of the
people
crime
here.
or the deceased.
Actual opportunity,
In this
actual
case,
motive, actual
An attempt to
constitutional
call Mr.
guilt.
Higgins a liar or create fictions about what they think he could have been doing or guessing what they want him to do is not evidence. 9 people testified John never came into the house. 9 people.
Huh? And they all lied.
There is no overwhelming evidence or any evidence he went into the house. There is no evidence of motive on any of these 3 people they identified. They've had, before the last trial, the entire trial, and was aptly pointed out, no request for a third-party culprit instruction. And then they had since then to make an actual proffer that people actually have the motive, opportunity, and intent to do this, that there's actual evidence that there's this alternative theory, and they failed to do it.
Actual.
To have the defense go through a trial, distract the jury,
Because you have no actual
attack
argument,
the
Mr. Brennan.
reputation and character of the witnesses,
You just
and
rely
then
on
not
these
even ask for an
actual
instruction at the
absolutes.
end.
And this
It's
actual
evidence of the
denial and
fact
willful
that there is no
blindness.
basis for a third-party culprit. Now, separately, third-party culprit is part of Bowden. Even if the defense at the end does not warrant an instruction, I recognize that challenging the police investigation is virtually an entitlement of a defense. How they do it and the extent they can do it is a different story. Simply because they have an attack on the police investigation does not let them use third parties as part of that. And so the standard, Silva Santiago, is very clear. It's cited by
Well, you don't want them to use experts either, do you?
There has to be something
So
the
how
police
exactly are they
didn't
to
do
challenge
at
it?
the time that they knew about and should have done.
Yes. The
So at the
suspicious
time the
people,
police did their
suspicious
investigation is being
behavior,
criticized,
the
they would have
suspicious
had to have
circumstances
known
should
about
be
a potential
investigated.
third-party culprit or third-party culprit evidence and didn't pursue it. And that's where the defense argument utterly fails here. Because at the time the police were doing this investigation, what they knew is that John O'Keefe was on the front lawn of 34 Fairview near the street. They knew that he was dying or is dead. And a
they
number
thought it was a
of
fight.
witnesses knew
Thought maybe you've been in a fight.
that Miss Reed was saying, I hit him, I hit him, I hit him.
Well, they didn't
A number
actually
of
know that, did they? Because that didn't come up until
Shortly
later.
thereafter,
And
what the
Sarah
police
said she
knew
didn't say that. And she's
is
not on
that
video saying
Miss
that.
Reed's taillight was cracked. And shortly after, what they learned and knew after they got her car is that part of her taillight was missing. So at that time when they were doing their investigation, there was no claim of dog bites. That came months and months later. They went to 34 Fairview
Literally
and they
happened
spoke to
that
the
day
owner.
multiple
according to
times.
witness
Thought it was a
testimony.
domestic.
And everything
Thought he'd
seemed
been in a
appropriate.
fight.
Concerned, confused, no blood, no scratches, no cover-up, no turned over furniture. There was nothing that would have alerted the police officers that there was any road to follow other than the road they followed. Now they can be criticized for plastic cups or leaf blowers, but that's different. That's different. In order to have third-party culprit under Bowden, the police would have to have known that there was information that targeted or pointed out a different person, and they didn't pursue it. So in the cases cited by both the Commonwealth and the defense, there are a number of cases that talk about information that was known to police at the time they were investigating and they failed to pursue it. That is not this case. That is not this case.
Ipsy Dixit, it's not this
There was
case.
nothing in any of these proffers that show actual evidence that the police knew of these later third-party culprit claims by the defense, or they knew at the time they were doing this investigation that there was any other lead. And likely the reason is because there wasn't. The evidence for a reasonable police officer pointed towards the statements, towards the car, towards the light, and that was followed up, which led to DNA in hair and all the other evidence that followed, the data. And so as a concession to the defense, they don't simply get to bring in third-party culprit through Bowden because they failed in the instant case to show a third-party culprit. That's not part of their entitlement. And mindful that if they do raise Bowden, whether they get instruction or not, it is broad. And that means the police, including any police they would call in this case, or we would call, is entitled then to share their state of mind why they did not do something. That can open
we'd
doors
love
to
to hear
inadmissible
their
evidence,
explanations.
privileged materials. The state of mind of the officer is relevant if they make it relevant. So we should not engage
It's not like they didn't do that last time.
in a process where we allow witnesses to be asked questions with no ability of the defense to follow up those questions with actual proof. We should not engage in a process where witnesses, their character is attacked when it has no relationship whatsoever to this crime. And witnesses shouldn't be put through the ordeal of defending themselves based on generalizations about supposedly being violent or having a temper. There needs to be that nexus, and it fails. It is beyond feeble. And so I ask Your Honor not to allow third-party culprit in the instant, and you should not allow it as part of Bowden.
All right, thank you.
Okay.
Yes.
Mr. Yanetti is going to give it to us. Great.
Your Honor, the Commonwealth's motion raises three interconnected issues, not just two. I believe that two of those were conflated by the Commonwealth. I'd like to separate them out. The first issue is the introduction or admissibility of evidence relevant to show that somebody else harmed John O'Keefe. The second issue, which I think was conflated with the first, is whether after the introduction of such evidence, the defense is allowed to argue that a specific person or persons caused John O'Keefe's death. And then the third issue is whether the police properly investigated this matter in light of the information that they had or information they could have obtained or failed to follow up on to show that somebody else caused John O'Keefe's death. Regarding the first issue, which Mr. Brennan spent a lot of his argument on, there is ample evidence tending to show that somebody else caused John O'Keefe's death.
Yep.
In our opposition, we have cataloged the evidence against each of the potential third-party culprits that we named the last time we were in court. Each one of them had a motive and an opportunity to harm John O'Keefe. The investigators in this case had evidence that pointed to Brian Albert. Brian Albert is a violent man. He was not only a boxer who punched people in the ring, he was also a violent drunk who sucker punched other police officers. Those police officers are on our witness list.
Nice.
He's been investigated by the Boston Police Internal Affairs for having done so. There are many police officers listening to this argument right now who are nodding their heads. We've heard from many of them.
Nice.
It's undisputed that Brian Albert was present at the scene of the crime. It was his house. He claims to have been sleeping merely several feet away from where John O'Keefe's lifeless body was later found. There is evidence that John O'Keefe entered Brian Albert's house. The Commonwealth may not agree with that interpretation of the evidence, but it exists. It's a live issue at trial. At the time John O'Keefe entered that house, an intoxicated Brian Albert was inside. He had been drinking day and night for hours at a time, and he was liquored up. He testified to that. He was at the hillside when he had his first drink in the afternoon, and he testified under oath he was drinking consistently the entire rest of the day and night. The Commonwealth says that every single person didn't see him in the house. Those same witnesses that the Commonwealth points to, every single one of them also did not see him on the front yard where Mr. Brennan claims that he was at the relevant time period.
Good point.
That day and night, Brian Albert was attached at the hip to his close friend, Brian Higgins. This was the night that after having carried on a flirtation with Ms. Reed while she was dating Mr. O'Keefe, Brian Higgins was confronted with Ms. Reed and Mr. O'Keefe together. In the words of one eyewitness, Ms. Reed and Mr. O'Keefe appeared to be lovey-dovey that night. Higgins had expressed his interest, but it went nowhere. And it went nowhere because prior to January 28th of 2022, Ms. Reed had rebuffed him, essentially ghosted him. She stopped returning his messages. Brian Higgins was liquored up that night as well. They're both very large men. The court saw them on the video. Friends who drank the entire day and night, and they were waiting in the house for Mr. O'Keefe to arrive.
And they had Chris
Mr.
Albert
O'Keefe
get his contact information just to be
because
sure.
He went to Brian
Get a
Albert's
hold of
house.
him, get him over there.
After Brian Higgins left, Brian Albert maintained contact with him. At 2:22 in the morning, the two of them were exchanging phone calls to check in with each other just a couple of hours after Mr. O'Keefe was mortally attacked. Mr. O'Keefe had dog bites and or scratches on his arm consistent with a dog or an animal attack. Brian Albert had a large German Shepherd who had attacked and injured somebody in the past. It all fits. The Commonwealth utterly failed to investigate Brian Albert as a potential suspect. And I'm sure the court remembers the words in a text message of now ex-trooper Michael Proctor,
Now,
the lead investigator who's now been fired as a result, in part, of being biased in this investigation.
yes, well said.
I would point out also that when Mr. O'Keefe was in the house, both Brian Albert and Brian Higgins were unaccounted for, according to the testimony. With regard to Michael Proctor's words, he was asked specifically if the homeowner would catch any grief for having a deceased person on his front yard, and Michael Proctor said, nope, the homeowner is a Boston cop too. The message was clear.
Yep.
If you're a suspect, you get fully investigated unless you're on the right side of the blue wall.
Yep.
If you're a police officer, you get a pass. Now, in addition to the 2:22 a.m. phone calls with Higgins, there's other consciousness of guilt evidence implicating Brian Albert. This is not something that Mr. Brennan addressed in his argument. He didn't talk about the consciousness of guilt evidence. Despite a massive police presence on his front yard, just feet from his bedroom, Brian Albert never came out to speak with investigators. And it's worth noting, it's worth stressing that Brian Albert was a first responder. He chose to ignore his duty to help somebody in need and instead stayed in his bedroom. And Brian Albert's dog, the family dog, a member of the family for 7 years, Brian Albert got rid of the dog, shipped it to another state, only after it was made known in court that the defense was alleging that the dog had been involved in the attack on John O'Keefe. We showed photos of John O'Keefe's arm in a public hearing where it was clear to any unbiased observer that Mr. O'Keefe suffered those particular wounds from a dog or animal attack.
That's pretty clear.
Brian Albert responds to that allegation by essentially divorcing his family from their beloved dog, whom they had had for 7 years and certainly considered to be a member of the family. In the aftermath of John O'Keefe's death, Brian Albert went so far as to send that family member to another state. That's enough evidence to point to Brian Albert as a potential third-party culprit in this case. It's evidence that he had the motive, intent, and opportunity to hurt John O'Keefe. Brian Higgins is another potential third-party culprit.
Yep.
Like Brian Albert, Brian Higgins was present at the scene of the crime. He was there at the relevant time in the house, again, unaccounted for, at the same time John O'Keefe would have been there. Brian Albert had cause to back up his friend, but it was Higgins himself who was the one who had been flirting with Ms. Reed in the weeks leading up to January 29th. He testified that she kissed him goodbye after they had watched an NFL playoff game at a get-together not long before January 29th. He testified that she had visited him at his apartment after that, but he acknowledged that their text exchange and all contact between them ended, and Ms. Reed was the one to end the contact. She stopped responding to him.
She ghosted him.
She no longer gave him any attention. So we come to January 28th.
No attention.
Brian Higgins sees Ms. Reed in person, but she's not alone. She's instead with Mr. O'Keefe. Ms. Reed and Mr. O'Keefe are affectionate with each other that night, and Higgins is there to see it, as is Brian Albert. There's evidence that Mr. Higgins wants Mr. O'Keefe to come to the Alberts' house that night. In fact, he appears fixated on making sure that Mr. O'Keefe went there. In the waterfall video, Your Honor, you will see that Higgins motions to Mr. O'Keefe when they're leaving. And Higgins even texts him directly after that to make sure.
Show the motion. It's pretty aggressive.
Then Higgins goes to the Albert home. John O'Keefe goes inside. Higgins is there waiting for him, with both the motive and now the opportunity to hurt John O'Keefe. Like Brian Albert, there's evidence of his consciousness of guilt as well. After a long day of driving and drinking, Higgins leaves Brian Albert's residence, does not go home. Instead, he goes to the Canton Police in the early morning hours. He initially claims he went there to do administrative work. He changed that testimony at trial to him going there to move a vehicle. But he's always maintained, including in the first trial, that he never called anyone. We've learned since that trial that Higgins is at the station on video making a phone call. So I suppose the question is, why did he lie about that? The jury in this trial should be entitled to consider the answer to that question. And of course, the police never investigated who he was calling or what he said or who was calling him.
Did they get his phone records from the feds?
And at 2:22 in the morning, he's speaking by phone with Brian Albert. And he claims that they didn't, but the phone records don't lie. And this notion that these two men are somehow able to butt dial and butt answer each other is just ridiculous. And there's more consciousness of guilt evidence with regard to Higgins. When he realizes that investigators might be interested in the contents of his phone to see what evidence might be on it, he demonstrates consciousness of guilt by getting rid of his SIM card and the phone itself. And how he got rid of it was extraordinary and demonstrates just how badly he wanted to keep that information out of the hands of investigators.
$1,000,000%.
He admitted to breaking the SIM card into and making a special trip to a military base to put this tiny object, the size of about a thumbnail, into a large dumpster. It wasn't enough to throw it in a waste paper basket or a trash bin outside the local Dunkin' Donuts. Instead, he went through security at a military base and secretly tossed this tiny broken SIM card into a dumpster.
Well, they were doing that weight loss challenge,
that
remember?
Investigators would never know what's on his phone, and he admitted to that at the first trial.
Wings and potatoes.
And of course, the investigators in this case, including the lead investigator, former trooper Michael Proctor, never showed any interest in Higgins' phone. Higgins nonetheless accomplished his goal of keeping the contents of the phone out of the hands of the defense in this case. That's powerful evidence of motive, intent, opportunity, and consciousness of guilt of Brian Higgins. As Mr. Brennan acknowledges, all doubt should be resolved in favor of the admission of third-party culprit evidence, linking him to the harm caused to John O'Keefe. And finally, Colin Albert is a potential suspect. He had been in a feud with John O'Keefe. He'd thrown beer cans in his bushes, told him to F off. We have a good faith basis to claim that. This is the same Colin Albert who testified under oath he had never been in a fight in his life, yet there were videos of him clearly desperate to beat up others. The same Colin Albert who had scraped up knuckles just a few weeks after John O'Keefe's death. Those knuckles looked consistent with an attack on somebody. The photographs that Mr. Brennan references that were allegedly before that photo had no metadata. We can't confirm when those were taken. Mr. Brennan wants us to just accept the testimony that they were taken before the scraped up knuckles photo. We don't buy it. We don't think a jury will buy it. When John O'Keefe was found, he had 2 black eyes, looking like he had been punched in the face. Colin Albert was at his uncle's house with both his uncle and Brian Higgins, disliking Mr. O'Keefe for a different reason, but disliking him nonetheless. And it's suspicious that Colin Albert's name was purposefully omitted out of the police reports. There was no indication in any police report provided to the defense in the first few months of this investigation that Colin Albert was ananywhere close to 34th Fairview, his uncle's house, on January 29th. In fact, there's no indication in those police reports that Colin Albert even existed. Initially, we didn't even know who he was.
The cut over
But
his
we
eye.
found out when we sent a letter to Mr. Lally, while the case was still pending before a grand jury, notifying the Commonwealth that Colin Albert should be called as a witness before the grand jury. It was only after we sent that letter, notifying the prosecution that we were onto Colin Albert, that testimony was elicited that Colin Albert was indeed at 34 Fairview that night. The defense caused this to be revealed, not any investigator of this case. And there's obviously an inference that his name was kept out of the police reports to protect him. The same way Brian Albert is the only person listed in the initial report whose first name is not even spelled out. He's just listed as B. Albert with an incorrect address. There appeared to be a conscious effort of these investigators to hide third-party culprits from the defense. All of these men, Brian Albert, Brian Higgins, Colin Albert, were present at 34 Fairview the night that John O'Keefe was killed, and each had a motive, intent, and opportunity to cause him harm. Now, there are many cases, Your Honor, I know the court is aware of this, endorsing the admission of third-party culprit evidence. Almost all of them allowed in a third-party culprit defense, despite a lack of evidence that the third-party culprit in those cases was actually at the scene of the crime at the relevant time. The first case cited by the prosecution, Commonwealth versus Conkey, Middlesex County case, I remember it from the 90s, it was retried in the early 2000s. In that case, a person was murdered inside a home, just like this case. Unlike this case, however, the defense could not place the third-party culprit at the home when the murder was committed. He lived down the street, and that was enough. Here we have hard evidence, irrefutable evidence, that the 3 potential third-party culprits were present exactly when the murder was committed. And it's notable that the defense in Conkey, in that second retrial, after the first conviction was reversed, the defense was allowed by the trial judge to present a third-party culprit defense, and it wasn't controversial. But the conviction was nonetheless overturned, the second conviction, on appeal, because the trial judge didn't let the defense go far enough in presenting that defense. The SJC ruled that in addition to presenting evidence of motive, intent, and opportunity, the defense in that case should have been allowed to introduce past sexual assaults of the third-party culprit, including one that took place 7 years before the murder. It was reversible error.
Wow.
Not to to permit a full third-party culprit defense, including prior bad acts of the third-party culprit. And I will ask the court to consider Commonwealth versus Finney, a case that I'm very well familiar, as I previously mentioned. I brought that motion for new trial. I argued before the Supreme Judicial Court, and I tried the retrial of that case.
And I won
it. I know it well. The SJC affirmed Judge Ball's allowance of the motion for new trial in that case, ruling that it was ineffective assistance of counsel that the attorney did not raise a third-party culprit defense. The case law makes clear, as Mr. Brennan again acknowledges, that this defense is a time-honored method of defending against a criminal charge.
Yep.
The defense should be given wide latitude to present relevant evidence that somebody else committed the crime. But the main issue in Finney was whether the defense could introduce hearsay to support an already admissible third-party culprit defense. So sort of like Conkey, where it's just assumed, yes, of course you can present a third-party culprit defense. But in Conkey, can you introduce unrelated sexual assaults from 7 years before? The answer was yes. And in Finney, of course you can present a third-party culprit defense. But can you also introduce hearsay to support that defense? It was a given, and in fact, it was reversible error that the third-party culprit defense was not brought the first time around. Mr. Brennan talks about, well, you can't do this if it prejudices the Commonwealth. That's crazy. Every single time you introduce a third-party culprit defense, you are prejudicing the Commonwealth by definition. You're not going along with their theory of the case. Mr. Brennan's aggrieved that we would deign to present this defense. I would note, Judge, you know, there's I believe a certain amount of gaslighting going on here in that on one side of his mouth, he talks about he wants Ms. Reed to have a fair trial. But we've spent weeks where he's just trying to knock out all our evidence, just limit everything. He's, I believe, acting more like a defense attorney than a prosecutor in that regard. But regardless, you know, in terms of these cases, Mr. Brennan said that they all have third-party culprits who have relationships to the alleged victim and/or relationships to the scene of the crime. Finney did not. In Finney, my client was the next door neighbor. My client signed a confession to the murder. The third-party culprit lived several houses away within the same city, but not close, not next door. There was no relationship other than he made statements about how the victim probably deserved what she got, and she wasn't the goody two-shoes, but there was no, that she was made up to be, but there was no, witness that put the two of them together in any way other than those hearsay statements. Nobody put him at the scene of the crime. The SJC ruled even hearsay should be admissible to support that third-party culprit defense. The defense in this case has more evidence of third-party culprits than the defense did in Finney. We're not asking this court to allow into evidence hearsay, as was admissible in Finney. We're solely seeking to introduce the crux of a third-party culprit defense, which is evidence of motive, opportunity, and means, all of which Brian Higgins, and Colin Albert had. That's the nuts and bolts of a third-party culprit defense. So that's the first issue, presenting evidence of a third-party culprit defense. The second issue is whether we can argue in closing that a third-party culprit is responsible for John O'Keefe's death. That's an issue I suggest that the court does not need to decide now in advance of trial.
Yeah.
Closing arguments come at the very end of trial. At the charge conference, this court would be in a position and would be entitled to evaluate the evidence as it came in and to make a decision at that time prior to closing arguments as to what we can argue and what we can't. And while we believe the court has enough evidence now as a result of the first trial and as a result of our proffer and our submissions and oral argument today to rule that a third-party culprit defense is permissible, but this court at a minimum
count on her
should not
actually
deny
remembering the
argument
first
on that
trial.
issue before evaluating the evidence as it comes in. And that brings us to the final third issue, a Bowden defense. Obviously, attacking the inadequacies of a police investigation is bedrock constitutional law.
Yes.
It's a bedrock constitutional right. In this regard, in one sense, the discussion about the third-party culprit evidence is somewhat academic as opposed to a practical one, because all of the evidence that points to Brian Albert, Brian Higgins, and/or Colin Albert, all of it comes in to show the lack of investigation, the lack of curiosity that the police had, and the lack of investigation that they did to rule any of them out. And it comes in to show the bias of the investigators of this case. Bias is also a constitutional right.
Yes, it
They
is.
were perfectly willing to jump to conclusions about Ms. Reed, someone outside their law enforcement circle, on the wrong side of the blue wall, but very much unwilling to be curious about whether someone within their circle had the motive, opportunity, and means to hurt John O'Keefe. Former Trooper Proctor specifically told his friends he had no interest in investigating someone connecting with law enforcement. And in their internal affairs findings, his superiors noted that his apparent bias was one of the reasons he was fired.
Yes, they
You can't
did.
have a stronger Bowden defense than that. So I would argue, Judge, that the Commonwealth's motion really comes down to what the defense will be able to argue in this case. Our position is we should be able to point the finger of guilt at those who might have done this, but at a minimum, given that the evidence will be coming into trial anyway on the Bowden issue, the court should reserve judgment on what we would be allowed to argue from now, weeks from now, when closing arguments are upon us. This evidence, in conclusion, in our view, must come in. This is a due process constitutional right of my client, and it has to be admitted for two reasons. Number one, it's a time-honored method of defending against a criminal charge by pointing out that somebody else could have done this. And number two, it's a time-honored method of defending against the criminal charge by pointing out that police investigators failed to do their jobs correctly. We have a stronger third-party culprit evidence situation here than existed in either Conkey or Finney, and we assert it would be reversible error for this court to exclude this evidence. Unless the court has further questions, I would rest on my memorandum.
Oh, yes, of course, follow up, of course. Defense didn't even address that, blah, blah, blah. Defense has still presented no evidence.
I'm going to choose to focus on case law and the facts that aren't presented by the defense.
Oh, they didn't present.
We see in their motion there's a grand claim that there's extraordinary evidence that John O'Keefe went into 34 Fairview that night. That is critical.
They didn't say extraordinary evidence.
Because
They
there
just said
is
they
no
could prove it.
basis to accuse somebody of murdering another person
Who says
if they don't have the
only
opportunity.
happens inside a house?
In other
Why have we
cases, the
concluded that
third-party
fights
culprit
have
is
taken
not
place on the front
necessarily
yard,
found at the scene,
Brennan?
even in Finney. It's more than just a couple derogatory words in Finney, as counsel knows. There was a neighbor who had an axe or a club. He was seen with blood, went home, washed his clothes, wholly irregular. And
So irregular to wash
because
your
of this
clothes?
irregularity and the timing,
Are
he
you
was
a
then asked by
homosexual,
his
Mr.
then
Brennan?
wife about the
Kinda sounded
victim,
like
and he
Higgins
made
might
a
have
number
been.
of derogatory comments about her, showing ill will, evidencing tangentially motive. And so no, a third party does not necessarily have to be at the scene at the time the police investigate, but they have to be with the deceased if they caused the death. It's obvious. And so we didn't hear any extraordinary evidence, none. We didn't hear kind of good evidence. We didn't hear any evidence.
They didn't
We
say
just have the
extraordinary
bald
evidence about
assertion
John
that the
O'Keefe in the house. They said
data
extraordinary
forensic
evidence
evidence will
about
show
the
that he was
card
in the house.
in the
It didn't,
dumpster.
it doesn't.
Military base.
They don't have a proffer. So there is no opportunity to murder John O'Keefe when all the evidence points to him dying on the front lawn from an alleged
You're
collision.
that impossible to have a fight on the front lawn. That's it. Case over.
The defense's effort to tell a story, take a couple of facts, someone's a boxer, they drank alcohol, and convert it into a story, is how they will try to portray these unsubstantiated facts at trial. They'll tell a story. It will divert the jury's
Kind of like
attention.
how you're going to
So
tell
they're
a
not
story.
entitled to it. They're not
How'd I
entitled to it.
hit him? And
Time-honored
taillight
tradition,
and all
yes,
that.
but there are limitations. Silva Santiago was very clear about the limitations.
And
This latitude is not unbounded. Each of these limitations recognizes the admission of feeble third-party culprit evidence poses a risk of unfair prejudice to the Commonwealth. I'm not whining. The Commonwealth should not be unfairly prejudiced. The people of the Commonwealth should not be unfairly prejudiced because it is inevitably, it diverts jurors' attention away from the defendant on trial and onto the third party. Essentially, it requires the Commonwealth to prove beyond a reasonable doubt the third-party culprit did not commit the crime.
Yeah, it does.
If there was
Yes, it
evidence
does,
of
Mr.
third-party
Brennan.
culprit, the defendant
Yes,
should
it does.
be entitled to
You
use
need
it.
to
In
prove
this
beyond a
case,
reasonable doubt
there
they
is
did not
not.
commit the crime.
there is no motive. There is no motive. To suggest that one person was pining, although the text messages don't show that, they both stopped corresponding with each other. days
Well,
before. To suggest that Mr. Albert is friends with Mr. Higgins and therefore he is bootstrapped into a conspiracy to kill with no evidence. certainly the defense can infer certain facts like getting rid of the SIM card in a way they want. And I don't begrudge that at all. There's different interpretations to it. I understand that. This was heavily considered in the federal investigation. And after
Way to
that,
briefly come into
thorough
contact with reality, Mr. Brennan.
investigation, there were no charges. There was no evidence of third-party culprit. There were no indictments.
The feds don't charge people for simple murder,
Although we
Mr.
don't know the
Brennan,
parameters of the
as you
federal
know.
investigation, and we can only guess as to some of it, we know from what we did receive and review, it was thorough. And if there was third-party culprit evidence, we would expect that there would be a basis for it. It's not an entitlement to simply bring it in under Bowden. I don't defend that there was commentary in the officer's phone that was inappropriate. But that doesn't automatically create a situation where there is evidence that the police officers knew that there was somebody that should have been investigated. In fact, when Mr. Albert came down the stairs, the testimony is the police officer was already inside his home.
To
There's no evidence
investigate the fucking
Mr. O'Keefe, the
homeowner?
first responders, was still outside that aid could have been rendered. That is just, it's not only speculative, it's just piecing together different facts and telling a story. So inevitably,
They don't actually
while I
know guys
recognize
still alive.
the
They
case
should
law, there
hang
are
out. Oh, it's cool.
plenty
I
of
don't know if
cases
you
that
need
talk
help, really.
about third-party culprit
That's
should not be
really-
admitted if inappropriate. Commonwealth versus Stedman. In that case, a person, not the defendant, was in a fight with a person at a campsite. And then later, the defendant supposedly went back to the campsite, a friend of this person, Royal, and used a knife to stab and kill him. And the defense wanted to introduce prior convictions about the fact that this supposed third-party culprit had attacked people at other homeless sites. Pretty close relationship. A person having a history of attacking people at homeless tent sites. And the court, looking at 403, did not allow it as third-party culprit.
Well, if that's all you
They
have.
said that the admission would be feeble, pose a risk of unfair prejudice. In that case, there was third-party culprit
Didn't
admitted
happen at
pursuant
his
to Bowden in a
house.
very different way.
Kind of different, isn't
Commonwealth
it? than
versus
the
Moore.
campsite?
The court would not admit layered hearsay showing different identifications that were relayed by the police from third parties regarding a culprit. They said that the hearsay was uncertain, the source is unreliable, and it was inadmissible as third-party culprit. So it is not an entitlement to be third-party culprit. Commonwealth versus Buckman, 461 Mass. 2011. The defendant was charged with murdering his wife. When they received a report from one of the defendant's friends, the defendant was softly tied to a pole to look like he had been kidnapped.
Softly
Inevitably, the police
tied to
determined that
pole.
he had help or tied himself as a ruse. And this person, the helper, his friend, had connections to gambling, was there, and when the police couldn't find the body, he knew exactly where the body was. That case is far stronger than many. And in that case, no motive, no intent,
Well, that's great. That's nice
and
that there are
they
strong
did not
cases,
let a
Mr.
third-party
Brennan.
culprit defense go forward.
Do you have any way to compare that to this case besides pounding on the desk and insisting no evidence?
Facts suggesting that one side believes a person's telling the truth or not is not facts of third-party culprit. It's just not here in this case. And again, I iterate my position on denying the defense to cross-examine witnesses about these generalizations and these character attacks. I think it will mislead the jury, and it will become a total diversion for the jury. And I don't think the basis is anywhere close. It's feeble.
That briefly respond? Thank you. First of all, Your Honor, speaking about the federal investigation, when you were not a part of it, and talking about why a federal grand jury was convened, what they were investigating, what they found or didn't found, is complete speculation. Should not
Yes,
be
it
a
is.
part
Thank
of this
you.
argument. We don't know. It didn't prove anything. It's not as though they came up with a statement exonerating anyone. So that should not be
Like a
considered.
no
by the
bill
court.
or something?
With regard
Not like
to
they did that.
the two cases that Mr. Brennan cited, You'll note that in one, he talked about the exclusion of hearsay evidence. There's a different standard when you want to introduce hearsay evidence as part of a third-party culprit defense. There need to be substantial connecting links to the crime itself. The court ruled in that case there weren't. In Finney, there were. And with regard to the other case, that's with regard to hearsay. With regard to the other case, that was the exclusion of past assaults to show that somebody was violent. Again, Commonwealth v. Conkey is a case where they said, well, that should be, in addition to a normal or a regular third-party culprit defense, you should also be entitled to that evidence. So that's not very instructive. The other two things I just wanted to point out, because I did not mention them, Your Honor, is that Brian Albert also disposed of his phone. We'll never know what was on that. That's further evidence of consciousness of guilt. And then an important point is that the plow driver, Mr. Loughran, went by the house at 3:30 in the morning and saw a Ford Edge parked in the very area where John O'Keefe's body was found. And we know from the evidence that the Alberts, both Brian Albert and Colin Albert, owned a Ford Edge. So that is in the mix as well. And unless the court has any questions, I would rest on that.
All right, thank you very much.
Thank you.
So let's go on to paper 620, the Commonwealth's motion for production of records regarding unsolved productions.
They want more background, more edited stuff.
May I?
Yes.
Your Honor, the Commonwealth filed a Rule 17 motion for records from unsolved productions. It has been discussed briefly in court at times during argument. There was a so-called documentary that was aired in a 5-part series. It gave a inside, behind-the-scenes look of the defense team and Ms. Reed as it prepared for the last trial. This 5-part docuseries produces a number of statements from the defendant, many of them extraordinarily relevant, some of them from the Commonwealth's perspective extraordinarily incriminating, and many of them inconsistent with statements made publicly in the past, including Dateline 2020 into Gretchen Voss. We serve the local service in Boston, a local agent. The record holder is the producer of the series, and they have been notified. If the court allows this motion, I expect they will provide the information to us by the end of the week. I understand there is probably over 200 hours of recorded interviews, and we expect to use a number of those statements at trial. They are statements of the defendant, they're admissible substantively, they're admissible as admissions, and they're admissible to show contradictions with other statements. And so they are material and relevant. I understand the time frame. We haven't had the privilege of seeing them. The defense was there for a part or most of it, but we will use the time we can to sift through it. We're not looking for a continuance or additional time to look at the materials. We'll look at them as we prepare for trial. And so I'm asking you to grant this. It clearly makes the Rule 17 standard material relevant. We don't have access to these before trial. We won't be able to prepare for them if we get them pursuant to a trial subpoena. They've been properly subpoenaed and they're forthcoming with a court order.
Is there one here from Unsolved Productions opposed to this today?
There is not.
Does defense want to be heard now?
Oh, I thought they didn't have standing.
Of the communications back and forth between the Commonwealth and the production company. So we've not been privy to that. This is the first we're hearing of any communications that they've had with the production company. I think obviously in an abundance of caution, they should be given an opportunity to oppose if they wish. Nothing official has been filed one way or the other. So we're not in a position to argue on their behalf for sure.
All right. Let's get that under the buzzer. So,
I guess you can rule on this
Two
one,
things
like
left
did
to
not
discuss.
rule on
I
the
want
first
to
one.
talk about jury impanelment. We
Oh, no.
also have a Commonwealth motion regarding Mr. Yanetti's claim. Mr. Yanetti, it's 12:10. Which one do you want to go forward on first? Do you want to talk about the impanelment, or do you want this motion?
I'm not handling either of those.
I understand, but do you have a preference what's done before lunch? All right, so let's do that motion. Commonwealth's motion to compel communications between the defendant and attorney.
Yes, we knew she'd want to do this one. She seems remarkably subdued about this motion.
Your Honor, so I'm clear, the Commonwealth is not seeking all communications between Ms. Reed and Mr. Yanetti. We're only requesting the communications that may be on any type of records in the possession of the Commonwealth. And specifically, there are phone records which have been redacted, and I do not know what is underneath those redactions. And we believe we have an entitlement to the information in the narrow area where Ms. Reed has waived her attorney-client privilege. Specifically,
Well, you
where
didn't say it was that narrow,
the
'cause you're
defendant
on the
intentionally
subject matter.
divulged the content of her communications with Attorney Yanetti about liability and potentially striking John O'Keefe with her car. Those subject areas in that narrow time frame are no longer privileged because they're now public. The Commonwealth has identified a very narrow window, and that's a 3-day period. And that is what is mentioned by Ms. Reed in her public statements, that she spoke to Mr. Yanetti and she thought about it for 3 days. We're not looking for any information beyond what has been waived. We're not looking for any information on collateral issues, and that's why we suggest that the court look at those records in camera, and the court makes the assessment whether or not the area where Ms. Reed waived her attorney-client privilege, whether any of those materials would similarly be waived because they are exactly related. This is made in good faith. Anything that is non-privileged is open to the public. It's not confidential.
What's your good faith basis for thinking they're in?
There are 2 communications
messages,
that
Mr.
Ms.
Brennan,
Reed
because they
made
shouldn't be
publicly
by your
that
own
we
story.
assert waived the attorney-client privilege as it relates to that issue. Ms. Reed had an interview with Gretchen Voss on June 20th, 2023, and the transcript is page 105, line 23. She was asked the question by Ms. Voss, "You never said, 'Did I hit him?' I hit him." And the answer by Ms. Reed was, "I said, did I hit him?" question mark. And then, when I talked to David, now this is later, David said, "Karen, if you incapacitated him in any way, there's culpability there." And I thought, all right, maybe this is what, maybe I said to my mother, just to go forward for a second, they were asking me, what was it like? Did they come out? What was the house like?
I don't think sitting on this
Similarly,
conversation that happened 2 years ago until right now is really your best
the
argument, Mr. Brennan.
Documentary
Because you could have
series,
raised it a long time ago.
Ms. Reed is
Maybe there's a reason why they
video and
didn't.
audio tape,
That email
and
that
it was
Mr. Valley
presented
got
on
about what's on the
television,
text.
that she said, and then when I hired David Yanetti, I asked him those questions the night of January 29th, like, David, what if I ran his foot over, or what if I clipped him in the knee and he passed out or went to care for himself and he threw up or passed out? And David said, yeah, then you have some element of culpability. So that's how I thought about it for about 3 days. And so that is where I get the time period regarding these relevant statements, admissions by the defendant about her state of mind and her interaction with John O'Keefe in her vehicle. These statements were made during conversations that are obviously no longer protected or private or privileged. They're no longer confidential because they've been intentionally disseminated to the public. And so the defendant has voluntarily waived that privilege as to these communications in this subject area in that time period. And the key, Your Honor, is that it is the defendant herself who made the communications confidential. Even if it was inadvertent or overheard, it would still waive the privilege. This is entirely different. There can be no doubt that there was an intention to
No,
pierce
if
that
it's inadvertent or
attorney-client
overheard,
privilege,
it
whatever
generally
benefit the defense
doesn't
thought
waive the privilege,
it gained.
Mr. Brennan.
This was
If they
intentional.
took reasonable
It wasn't
steps to try to
secretive.
keep
It
it
wasn't
confidential.
overheard. It was a exacting and purposeful engagement. So we ask you to review the cell phone extraction, any texts or emails that may be on those extractions, and relative to that short window, relative to this specific area, anything that is waived that is no longer confidential, we believe we're entitled to. It's obviously would be relevant if it's narrowly related to these statements, and we would use that at trial. Thank you.
There's no question this is a waiver.
I am, Your Honor.
Oh, yes, Mr. Alessi. Awesome. But what's his good faith basis for thinking that this happened by text? And they already have information about the privilege log that the defense provided with respect to her text. There's nothing about Mr. Yanetti on there. And according to their timeline, there should not be, because they would have happened after the Commonwealth got her phone and placed it in airplane mode.
May it please the court. The Commonwealth concedes throughout its motion, as it must, that the communications it seeks to intrude into are privileged communications between Ms. Reed and her attorney, Mr. Yanetti. 2 of the 3 instances of the communication they cite to are over 9 months old. And that's in 5 months old respectively. So you have 9 months ago, the Gretchen Voss statements, and 5 months ago, the Vanity Fair statements. But they waited until less than 2 weeks before the start of the trial to bring this momentous and potentially far-reaching and consequential motion.
Thank you for pointing that out.
The courts are
Sit on their
clear
hands.
that they take an extraordinarily dim view of parties waiting until moments before trial to raise significant issues like privileged communications this close to trial. The Commonwealth does not explain their delay in raising this issue this close to trial. With regard to the third communication, the HBO Max one, it regards the same event
As the
that
Gretchen
is
Voss.
discussed in the first 2. There is no addition of an event in the third one. So that third discussion, the docuseries, regards the same events that have been extant in the first 2 that have been extant for 9 months and 5 months. The depth of this attempted intrusion by the Commonwealth should disturb and unsettle every citizen of this Commonwealth, because they're either actual or potential clients of lawyers, and it should unsettle every criminal defense attorney in this Commonwealth, and I would dare to say it probably does. As we know, texts, emails, and written communications, exactly what the Commonwealth is seeking here, between an attorney and their client, are canonical examples of privileged material. So what is at stake in this motion? What is at stake is the sacrosanct attorney-client privilege. In Upjohn versus United States, the really bedrock attorney-client case from the U.S. Supreme Court, it established that dating at least from the age of Shakespeare, the attorney-client privilege is the oldest of privilege for confidential communications known to the common law. And this Commonwealth has identified that it is one of the most important, and it's been recognized in the Commonwealth as early as 1831. And in the context of criminal circumstances, the privilege has constitutional dimensions, as well as it affects the interests of justice analysis that is documented in the Commonwealth v. Goldman case, 395 Mass at 502. And it bears underscoring the basis and the depth of the intrusion is a quote from the very case and the only case that the Commonwealth cites in its motion. It cites one case in its motion for all of its propositions.
That's
Just
true.
one. Matter of a John Doe grand jury investigation, 408 Mass 480. In the case at 485 states, as we have indicated, extraordinarily high value must be placed on the right of every citizen to obtain the thoughtful advice of a fully informed attorney concerning legal matters. A rule that would permit or require an attorney to disclose information given to him or her by a client in confidence, even though such disclosure might be limited to the period after the client's death, would in many instances, we fear, so deter the client from telling all as to seriously impair the attorney's ability to function effectively.
Survives death.
We think that the potential is inconsistent with the traditional value our society has assigned. Here's a key point. In the interests of justice, and that's the rooting of the interest of justice analysis, to the right to counsel and to an effective attorney-client relationship. Therefore, except where mandated by constitutional considerations, and it cites C. Commonwealth v. Goldman, Super 395 Mass at 502, which are not a factor in this case, nor are they a factor in not a factor in that case, we conclude that the attorney-client privilege should not yield either before or after the client's death to society's interest as legitimate as we recognize that interest in obtaining every man's evidence. So the case the Commonwealth cites
That emphasizes the importance of the privilege.
the protection of the attorney-client privilege. With that law jurisprudential predicate in mind, I now turn to the statements at issue here and their import to that analysis.
You know what, Mr. Alessi, I'm going to stop you. I understand the Commonwealth's argument regarding waiver. I understand that the request is narrowly tailored. I'm not going to give you this information, Mr. Brennan. I don't even think it's appropriate for me to ask, so the motion is denied.
Wow.
Thank you, Your Honor.
Interesting. Too far even for Judge Cannone. I did not predict that. I thought she was going to be gleeful at the chance to be right about everything she thought about the publicity in the case.
The parties need 5 minutes.
All right, so the court, please.
Taking a quick recess here before coming back to talk about jury impanelment, I guess. Boy, I'm going to go ahead and stop you. She had heard enough. She had heard enough. That is pretty unusual. Oh, our fan isn't running today. That's going to be considerably less hypnotic, isn't it? Well, I got to tell you guys, frankly, I think Karen got very, very lucky there. I really do. I think she got very lucky. Anytime you are tempted to say the words, "My attorney told me," stop and shut up right there. Don't go any further. Don't go any further. The whole issue with privilege is that it's a secret. And so you get to keep the secret, or you can make it not a secret anymore. And if you decide you're not going to make it a secret anymore, what you guys said to each other, then you don't get the protection of it being a secret. So stop. As soon as you're about to say, "I told my lawyer and my lawyer told me," stop. And I have to tell you, when I was reading the motion and kind of the circumstances that were alleged in it, especially like the Gretchen Voss interview, the Commonwealth says that Mr. Jackson and Mr. Little and Ms. Little were present for that. And how those words escape your client's mouth and you have not like body tackled your client and put your hand over their mouth and told them you're going to stop right there and you're going to say this a different way and you're not going to talk about the conversations that you had with your lawyer, then I don't know why you're even there. I really don't. I don't know why you're even there. Like, that's the whole job. This stuff comes up a fair amount. I'll tell you examples in my practice where it comes up a lot that client is having to give conversation, having to give interviews about things that you may have had conversations about. There's a lot of overlap a lot of times between criminal charges and CPS cases, right? Somebody gets arrested for something, or there's drugs, or there's domestic violence, or whatever. The children are taken out of the home. These cases run along parallel tracks. And the CPS process is a civil one. It's not a criminal case. Because it's a civil case, that means they can use your invoking your Fifth Amendment rights against you. They could hold that against you and say that that's proof that you did it, or consciousness of guilt, etc., things like that. So you have to very carefully strategize when somebody wants to get their kids back and they want to fight the removal and stuff like that. They generally are gonna have to cooperate to some extent with respect to providing information. So not uncommon at all. I'd be appointed on somebody's criminal case. I'd be appointed on their CPS case. We got to go down and do the interview with the caseworker and have a conversation with them. And yeah, you absolutely bet we have strategized about that ahead of time. We have planned for that ahead of time. We have prepared for it. And so that's why I'm there. That's why I'm there, is to make sure we're carrying out the plan and you don't say something that you shouldn't say that would be a waiver. You know, my attorney told me it would be like, no. I will take you down like a linebacker if I have to. If I hear those words coming out of your mouth, you are going to stop right there. So that bothered me. It really did. Because if they were there and they let that happen, I don't know why you were there. I don't know what the point was. So my opinion, Karen got very lucky here. Never, ever, ever say the words, my attorney told me. I told my attorney, stop at that point, because yeah, you may be opening a door that you can't close back up. So very fortunate that was a bridge too far, even for Judge Cannone. Now, having said that, I don't know if it's because of the delay, if it's because she finds the request itself to be offensive, because she recognizes that it might be opening a little bit of a door with respect to potential conflicts with Mr. Yanetti. The reason the Commonwealth wants this isn't because they want her words to him and his words to her. They can use that through the interview. They can just put on the interview like they're already saying they want to do. They're looking for impeachment. That's the problem. They want to see she used slightly different words. Therefore, Karen changed her story. Look at how that works. How the tables turn. Suddenly you want to be able to do that yourself. That's what they're looking for. And so that's where the potential conflict comes in, because it's hearsay when it's out of court. Now, Karen's own statements might be an exception, but Mr. Yanetti's might not be. And Mr. Yanetti's recounting, his recollection of her prior statements, they may not be too. So the risk is Mr. Yanetti becoming a witness. That's the concern here. That's what they're trying to accomplish. So maybe Judge Cannone saw this down the road and thought, nope, we're not going to go there. That is a bridge too far. Yeah, I don't know about that. So, Very, very fortunate for Karen. And yeah, I was a little bit surprised with how sort of muted she was about this motion. I really did. My expectation for Judge Cannone on this one was that she was going to be so gleeful that the defense's publicity efforts had come around to bite them. I really did. I thought she was just going to be salivating over this. What's the good faith basis to believe these were on the text anyway? That's the whole other side of this. This was very much a be careful what you wish for situation for the Commonwealth, because if there were text messages on that phone that related to this 3-day period that they're saying they have a good faith basis to believe is there, that's a problem for the Commonwealth and for their timeline, the testimony that they gave about how they handled this phone, because they took the phone on the 29th from Karen's parents' house in Dighton. That's when they seized the phone. And according to either Proctor or Guarino, I forget which one, the phone was in airplane mode from then on out until the time it was extracted, and it wasn't extracted until August of 2022. So if the phone was in airplane mode, there's no way for it to update with other messages that you might have sent from a different device that would be, stored in the iCloud or something like that. You have to have a network connection for that type of thing to happen. So your absolute best case scenario for thinking that there are texts here is that you did not, in fact, secure the phone. You did not, in fact, put it in airplane mode. You allowed it to be connected to the internet, and therefore it's not in the condition that it was when you took it. You have a chain of custody problem. That's your best case scenario. What's your worst case scenario? They were looking around in this phone when they weren't supposed to? Because we kind of already had some indications of that, didn't we? Kind of already had some indications that they were poking around in this phone before they got the warrant all the way down in August. So, Judge Cannone, she has not had the best and clearest memory of everything that came out in the first trial. So I definitely don't want to assume that she remembered all this. But, okay, looks like they're coming back.
All right. So I looked at the proposed supplemental questionnaire. They're very similar.
The questionnaires.
So I have a question. So the Commonwealth on your number 5 on the first page. I don't like the 2 questions in a row, 4 and 5. I don't think we need 5. Is that okay with you, Mr. Brennan? I don't think we need both.
Needs to be done.
Yeah. So that's out. So I'll go through, actually, I'd like to go through the first page of each. The first page of the defendants, number 13. Do you believe law enforcement officers are generally fair and accurate in their investigations? Who's arguing this for the defense?
I can argue it.
All right, so I don't have a problem with that, but it makes sense that we put it after 8, those series of questions.
No objection to that.
All right, any objection to question number 13 and putting it at 9, Mr. Brennan?
I don't have any objection to moving it after 9. I think it's a bit one-sided. It leans towards, one-sided, but I don't have a strong objection to it.
13 is, do you believe law enforcement officers are generally fair and accurate in their investigation?
If there's an invitation to balance, I'll need a moment.
All right, so you can suggest something.
Okay.
Or
All right, so now moving on to the second page.
do you have any strong personal beliefs, or have you been exposed to any strong personal beliefs from friends and relatives about operating a motor vehicle under the influence of alcohol?
Document, it's not in the defense when it was removed, I guess. Is there anything about crash reconstruction testimony that would make it difficult for you to be fair and impartial in this case? I don't have a problem with that question, does the defense?
We didn't have a real objection to it, just wasn't a particularly useful question. We thought at the last trial, everyone said no, so in furtherance of trying to have additional space for more helpful questions, we just decided to exclude it.
All right, I think we'll keep it.
But it's not very
There's one I
helpful.
do want to get rid of, it caused problems last time, but we'll talk about that in a minute. All right, so thank you. So, question number 23 on the defense. Does the Commonwealth object to that question? I think it needs to be tweaked at the least, just a little.
We do.
All right, so what's the objection?
I think the question, the way it's written, invites a juror to potentially not follow the judge's instruction. And so I understand the attempt, the idea of it, the germ of it, but the way it's written, it invites, I think, a jury to, or a juror to usurp what their role is.
And what do you say, Ms. Little?
I think if we just tweak the language a bit, I mean, we're happy to hear some proposals from the DA as to sort of the particular issue to have this question. But I do think the question about the judge's instruction regarding, you're entitled to your own independent individual verdicts.
So they're always told that their verdict must be their own. So there's language in there's probably language in my preliminary instructions, there's language in the charge, certainly. So if it mirrors that language, I don't have a problem with it. Otherwise,
one says-
I might, so.
You understand that while the
to each
law
other.
requires you to deliberate with other jurors to try to reach a unanimous verdict, you have the right to stand by your beliefs in a case.
Number 25 in defense. If you had to vote today on whether Ms. Reed is guilty or not guilty of the crimes charged, what would your vote be? I tell them throughout the trial, they're not to speculate, they're not to make up their minds until all the evidence is in. I'm not going to even suggest that this is appropriate. So I'm not going to include that. There are enough questions on reasonable doubt, presumption of innocence, and defendant not testifying. So that's out. So the question, also, is there any reason why you do or do not want to serve on this jury? I don't think we should invite them to decide whether they want to sit in this jury or not.
No, but they
I
should
think
be
we
able
did
to
this last time.
comment
I don't
on
know
it.
what the responses were. Does anybody have any information on that for me?
I think most of them were no. I think 27 kind of hits the same sort of, if
Right,
you have
if that-
general concerns about the case, so I don't have a strong objection.
If that's what we're getting at, we've got it in 27. So I'm inclined not to put it on there. Again, I can hear from you beforehand, probably in writing, I don't want to bring it back.
I kind of think it's a good question.
May I alert the court's attention, there's two on the first page that were slightly worded differently in the Commonwealth proposed questionnaire and the defendant's
Oh, okay, which
proposed
numbers?
questionnaire. If the court looks at number 4 on the defendant's questionnaire, we had kind of combined the Commonwealth's proposed questions 4 and 5.
Yeah,
So that's one question.
so that's, and I just got rid of Commonwealth 5.
Perfect.
So this one's better, so we will use,
I think the Commonwealth is better
Okay,
personally,
and
but
then number 7 that was proposed by the defense, that is the same, similar question as number 8 in the Commonwealth's proposed questionnaire.
yes,
It's just different language.
I thought it was the same.
So we changed it to
Tend to
say, we
believe
tend to believe, or
versus
basically law enforcement
automatically.
officers, firefighters or first responders, more than a civilian witness simply because of their occupation, as opposed to automatically believe.
So we typically ask the automatically, what's the Commonwealth's position on this?
I have a strong preference, I'll defer to the court.
All right, so I will think about that, Ms. Little.
Thank you, Your Honor.
All right, so the question that I don't like, and you may remember, causes a lot of jurors to say, I have no idea what you're talking about. 21 on the Commonwealth's, 20 on the defense. So you may
circumstantial
find a
evidence.
defendant guilty based on circumstantial evidence, but you cannot find a defendant guilty based on speculation, guesswork, or surmise. Is it difficult for you to understand the difference between circumstantial evidence, speculation, guesswork, and surmise?
I'm sorry, can you repeat that?
It's your number 20. I'm not gonna read it again.
Once again, I like the Commonwealth a little bit better here.
I think in every single one, I had to repeat myself, with the instruction that
At
I
least-
gave in anticipation of this. I gave them a
As far
pre-charge
as the
on
end?
circumstantial evidence and not being able.
Yes, just the way that it's phrased in the Commonwealth's questionnaire, it makes it seem that the Commonwealth doesn't have to meet their burden of proof.
I think it should be omitted completely.
I have no issue with that, it's just the way that it's
Does the
phrased in the
Commonwealth?
Commonwealth's questionnaire.
It's too confusing in my mind.
Okay, it took up, if you remember, it took up an inordinate amount of time, with virtually every single juror.
So it's an important thing to
Alright,
talk
so that
about
would be
then.
omitted. Alright, so that's that. Ms. McLaughlin, I think you said, and I think I cut you off the other day, the third page was right from Chisholm. I reread Chisholm on 95 pages of it the other day, and I didn't see it. Where does this third page come from? The publicity one.
The questions come from Chisholm, that were asked in the juror questionnaire. The other, some of the other cases, questions were part of the juror questionnaire in the prior trial. That just moved over to this page, so this page dealt with a questionnaire exclusively on pretrial publicity.
Okay. All right, I think that we all know many, if not most, and perhaps all potential jurors have heard about this case. Giving them the opportunity to write the details that they recall down may take an awful lot of time and space that we don't have on this form, and frankly, I don't think we have. So.
It's ineffective anyway, as we learned from the Koberger case.
Three.
Your Honor, if I may, I can just hand up the excerpt from the Chisholm case that outlines the.
They need to be prompted is the problem.
All right, I'm not sure 2 lines are enough space for it, frankly.
No, and then they're going to be extra selective with what they say too. They can't say everything in 2 lines if they watch the first
So
trial.
We'll see what we can do. I didn't realize it came directly, same language. Okay, looks like we're giving this third page of the questionnaire. Yes, Mr.
Your Honor, I want to bring the court's attention something about, the court and counsel just discussed question number 7. Could I ask the court to direct its attention to
All right,
question?
which page?
Sorry,
Current page or previous
The
page?
defendant's questionnaire on the first page.
Tend to believe law enforcement
That was
versus
the question, whether
automatically
the court's
believe
going to
law
consider whether
enforcement.
to use the word automatic or tend to.
Yeah.
I believe that should be broken into 2 questions. It doesn't tell us anything. For instance, the way it's written in the disjunctive, would you tend to believe or disbelieve law enforcement officers, firefighters, first responders, more than civilian witnesses, just simply because of their occupation? If someone says yes, we don't know if that's believe or tend to disbelieve. So I think if we just break it into 2 questions and now we've got the space to do it, that would be more instructive.
Why does it matter if it's an automatic belief?
I'm not worried about the automatic part, it's the believe or disbelieve. That's the part that doesn't help us.
Right. So
Will you
if it's
automatically
automatic,
believe them,
simply
or will
because
you
of the
automatically
person's
disbelieve them?
occupation, this juror would automatically either believe or automatically disbelieve. How does it make that person fit juror? Why do you need it?
Because that tells us.
That's bias.
It would instruct me at least, it would enlighten me on how to further question that juror. If someone says, well, I automatically
They might be
disbelieve
challenged
police
for
officers,
cause,
or
Judge.
I automatically believe police officers. Those are 2 very different mindsets.
So I understand that. I'll consider it. I think we keep it as 1, and then if they say yes, we inquire into it.
Okay.
Maybe. Let me see.
Okay, thank you.
All right, so it looks like we have the third page as well. I think, I have the statutory questions that I would ask of the Nairi. If we take that question that Mr. Jackson just talked about, I can ask each individual juror, if I use the tend language, if the testimony were in conflict, would you tend to believe the testimony of a police officer more than any other witness simply because he or she is a police officer? And then conversely, would you tend to disbelieve a police officer simply because he or she is a police officer? I typically do that at sidebar in every case asked exactly like that. So it makes more sense to me that we do it that way rather than a questionnaire. But if you want it on the questionnaire, we'll see as is. So what's your thought, Ms. Brennan?
That would be the defendant's preference.
Do you care, Mr. Brennan?
We prefer a questionnaire.
All right, so I'll think about it, I'll do it one way or the other, and you'll know next week. So one of the things that I was considering doing, so we have a lot of jurors coming in next week. On Tuesday, 218 jurors have been summoned, is my understanding. We will get some portion of that, we will get some fraction of that maybe, just on how it goes with whether people are here and available to testify on that date, to serve as jurors. So say we get like 150 or 175 jurors. I have my remarks to sort of just direct them to what their job is, as you remember, and then I leave and I give them the questionnaires. My guess is for the jurors to fill out this questionnaire, have the questionnaires collected and copied, might take an hour and a half or 2 hours if we have a really large number of people. What I intend to do, at least on Tuesday, is have all the jurors fill out the questionnaire, however long it takes. And depending on how many jurors we have and what time it is, maybe take 50 of the last jurors or so, send them home and have them come back the next day at 11 o'clock. If we've got fantastic court security here, hopefully we've got a courtroom to keep people in. There are a lot of things we have to juggle to get this done, and I don't want to waste jurors' time. So I would send them home, have them come back the next day at like 11, so that then the next day's jurors at 11 o'clock can spend that hour and a half, 2 hour process, filling out the forms, having them copied, given to counsel, and we can continue on with those jurors. So it's something we can decide on Tuesday when we see how many people are here, how many jurors we get, how many jurors the district court needs. But is that a process that you would be willing to do? Mr. Brennan?
Of course.
Do they fill out the questionnaires
So
on
we'll
different
try to
days?
figure out something that way to get things moving that way. All right, the list of witnesses, you both have a list of witnesses. I told you you needed to combine them so that I can read that to the jury and the statement of the case to the jury. Do you have that yet?
We have not combined them.
All right, so I need you to look at that, and a statement of the case to read to the jurors. It's all part of the final trial conference. So I should have had it last week. So I need that by Thursday. Is there anything else we need to discuss today?
There's still a few outstanding issues. One is Parker. And
Where do you
so,
stand with discovery on that?
I received some TUI letters last night. It is not information I was seeking from my motion that was allowed by the court. And so I have grave concerns about waiting for the day before their testimony to pursue the other discovery that I think I'm entitled to.
What do you say, Mr. Jackson? Mr. Jackson.
Your Honor, I do not know what Mr. Brennan is referring to with regard to what he's looking for and grave concerns. The hyperbole is unnecessary.
So there was a motion allowed, so that should be able to, there was a motion for the discovery allowed a while back.
It
So that
was,
should narrow,
Right.
right?
pardon me.
That should narrow things.
It does, and we have not, I attempted to confer this morning with Mr. Brennan, and my recommendation to the court would be for us to confer further, because I just don't understand what he thinks is out there, but we haven't conferred fully either.
Okay, all right, so do that, we can address this next week. I think we probably have plenty of time to sort of tie up loose ends during the impanelment process because I think it's going to take a very long time to get a jury.
Understood. And I expect we'll file a response to a proposed expert who received their report last night. And I didn't receive it until later, which I want to have a chance to respond to.
And Your Honor, if I could,
Another
please, one
motion.
more item when it's appropriate for Your Honor.
That's okay, go ahead.
Thank you. We did receive the, Your Honor may recall the argument over Dr. Welcher in Your Honor's direction, request, and then the assent of the Commonwealth that they would redo what they had provided, that 140 slide presentation. We did receive that, but we received a lot of other material in addition to that, huge megabytes. I haven't even been able to open it up. It takes so long to open it up. I respectfully request that we, Your Honor, grant us please 2 more days than what we had to take a look at that, because it's just taken an extraordinary amount of time.
Makes sense, Mr. Brennan?
I can be clear, there's no new information. What Mr. Welcher did is that all the information he based his opinions on was in the gigabytes we provided to the defense, but he wanted to make it as seamless as possible, so they'll effectively hold their hand through it. He put each site under each slide so they can find it in the file folders exactly where it is. So it's instructive and helpful, but it's not new.
Your Honor, if I may, I don't disagree with Mr. Brennan's characterization. However, it is still 140 slides or so. I was expecting a rather substantial narrowing, so what we have to do is we have to go, and unfortunately, I think Your Honor is going to hear similar points that we made, but it's going to take more time, because I had the expectation, maybe unreasonably so, that it would be a narrowed slide presentation, so I
Didn't
appreciate
sound
the
that
2
way.
extra days.
But a lot of stuff
So
was
when
written
is
out.
What was the time frame mentioned?
I'm sorry, Your Honor, I don't have the specific date handy right now.
The time frame as far as the response,
Yes.
but we were supposed to exchange discovery yesterday. And so I had that presentation sent over last night. They sent over the 2 letters, and I received the third dog experts report.
If I could, Your Honor, I maybe Attorney Brennan misunderstood the question. He is correct that he provided us with the presentation last night, but the question, I believe, Your Honor, was when was our time? Because Your Honor had given us time to respond, and I apologize, I don't have that date, but what I'm just asking for is 2 more days beyond it, but.
I don't think I gave it to you.
Yeah.
So you have 2 days to respond to that?
I have 2 days from today.
Yes.
Okay.
All right. So there are a few matters outstanding. I will have the decision on the motion to dismiss, I should by the end of the day, buffer zone, probably by the end of the day. And I'll get everything else done as quickly as possible. Okay. Anything else?
The only other thing is the logistical issue as it pertains to both the voir dire process as well as during the trial. I wanted to ask the court if there was a mechanism by which Ms. Reed could have at counsel table some sort of an earpiece or headphones or something that's slaved to a microphone up at the bench at sidebar so that she can listen in on both. It's very, I want to avoid that if possible. It's clunky. Especially during the voir dire process. I think it would be uncomfortable, and quite frankly, I think it would be a little inappropriate to have jurors with Ms. Reed standing right there with them and with us.
It's done all the time. So
It makes sense all the time, but
it may be something you're choosing not to, but she has every right to be there at sidebar. So you say you don't want that, you want some accommodation. I don't know if we can do it out.
You telling me you're taking Whitey Bulger up to sidebar to eyeball the jurors? That seems surprising for me, but.
Well, one of the things that we were talking about is potentially a closed circuit wireless microphone up at the bench and a set of headphones here that you can listen in on.
Put it all in writing. I
Okay.
would like to have had it before today. We're moving around courtrooms. It may not be able to happen.
Okay.
All right, so the alternative is she can come to sidebar for any sidebar discussion, impanelment, whatever. It's her absolute right. If she chooses not to do so, I'm going to need you to tell me that.
I'll put something in writing and perhaps I've got the plan in the back of my head. I'll put it in writing. And
We have a lot of different equipment that we need to make sure has priority. It's in the
Understood.
courthouse, so I'm not very hopeful that we can accomplish this in the next few days.
Okay, well, thank you for entertaining.
Doesn't sound that complicated, but
One thing, when we get the juror questionnaires, the supplemental juror questionnaires that we talked about, and I need you both know what my decision is here, other than the 10-2 versus automatic. Let's go with 10-2. And I can either do that at sidebar or in the form. What I'd like you to consider, and lawyers have done this in other cases that I've had, is if there are answers that are clearly what you believe would both sides agree jurors excused for cause. In an effort to be able to go through this vast amount of jurors that the jury commissioner's office was kind enough to summons in for us, if things stand out to you, it would be ideal if you could agree that jurors number 8, 12, and 16, both sides agree should be excused for cause based on the supplemental questionnaires. It would be very helpful if we could do that. And maybe keep a running sheet that would be a joint proposal to excuse these jurors for cause. It may happen when you look through the questionnaires, folks that we sent home to have them come back the next day, to just call 5 people, the court officers call them and tell them not to come in based on the questionnaire. So please think about that. It makes sense to me. It was very helpful when lawyers were able to get along well enough to do that in a case that we tried, that we had changed venues on, because of the pretrial publicity also. All right, anything else?
No, thank you.
Your Honor, there was a motion for reconsideration that was filed with regard to the metadata underlying, I can.
You can make an objection. Go ahead.
I just wanted to make sure that the court saw that motion and that it was filed. I don't know if the court wants to hear a full argument and have to do that, but we just wanted to make sure that that
it wasn't clear if it was moot.
All right, there's still a few months to do.
Thank you.
All right, anything else?
Not from this issue.
All right, we'll see you on Tuesday.
Court, all rise, please.
I'm glad she brought that up because I had been under the impression that motion may have been mooted. This was the one where they had argued, they had moved to get a forensically sound copy of the Sallyport DVR or the hard drive, whatever it is now that has all that Sallyport video stored. Judge Cannone had denied it, saying that, well, you didn't submit an affidavit establishing that what the Commonwealth wants to do for production purposes would be problematic, would destroy the metadata. They just said it in their motion. So a little bit of irony there, of course, because Mr. Brennan says things all the time in his motions without affidavits that she takes for granted. But when it comes to the defense, they needed an expert to submit an affidavit saying the Commonwealth's method is going to destroy metadata. So they did the motion to reconsider and cured that issue. They presented a declaration, an affidavit from Matthew Erickson saying Commonwealth's method going to destroy the metadata. And then after that, it just fell off the radar. And so what I had wondered is, well, did the Commonwealth just go ahead and do what they were proposing to do anyway once they got the ruling from Judge Cannone? And so now it's moot. The metadata is destroyed. We're done anyway. I don't know. So it doesn't maybe sound like that's the fact if Ms. Little is saying it's still a live issue to deal with. So I got just a couple of thoughts about this jury questionnaire. There definitely were some points. I'm going to go ahead and share a great side-by-side comparison that some folks did. Let's see here. The difference between the two different questionnaires that were proposed. And so we know now from kind of how she described the questions that 624 is the defense's and 623 is the Commonwealth's proposed. So it's got some of these differences. I gotta say there are a couple points where I think the Commonwealth did it better because it's more simple. The way that the defense did it maybe crammed a little bit too much into one particular question. So not so much on this particular one, but it is an example here. Any religious or philosophical beliefs that would make it difficult for you to follow the law and come to an impartial verdict. Those kind of are different issues. And so I do like that the Commonwealth went ahead and split that up. Then over here on the next page, this question right here, this difference, the defenses is over here on number 20. It is such a convoluted question. It is just such a convoluted on here. Such a convoluted question. You may find a defendant guilty based on circumstantial evidence if such evidence is proven beyond a reasonable doubt and to a moral certainty. I like that part. I think that part is good. But you cannot find a defendant guilty based on speculation, guesswork, or surmise. Is it difficult for you to understand the differences between circumstantial evidence proven beyond a reasonable doubt and to a moral certainty as opposed to speculation, guesswork, and surmise? I don't really like it the second time. I really don't. I think it's overemphasizing and it's getting confusing. Because the real issue here is just, do you understand the difference between being able to infer something from evidence and guessing at something for which there is no evidence? And those are very distinct points. I do think that that's an important one to get into. You gotta understand how the parties are thinking, but apparently it doesn't matter because I guess Judge Cannone isn't going to give this one at all anyway. It's too difficult. Okay, I don't like this approach of it's going to take too much time to cover all this stuff, and particularly when it came to the supplemental questionnaire with dealing with the media exposure. She doesn't want them to answer broad questions about, describe everything that you know about the case based on the information that you've already received. This process is how you get your foundation 99% of the time for a motion to change venue. If the press has been too pervasive in the community and it's been too prejudicial and it's making it too difficult for you to find jurors who are unbiased, this is how you make the record of doing that. And so, yeah, you need to be able to ask them a lot about what they already know about the case. She wants to keep it to 2 lines. If somebody watched the first trial, they can't put everything that they know in 2 lines. So they're already going to be going through a selection process or a categorization and analysis, a prioritization, like what do I emphasize and what do I leave out? And that's not really appropriate. It's not getting to the point. Now there's the whole other problem that we learned a lot about in the Koberger case with the motion to change venue, because they did that survey. They did that pretrial survey of the prospective jurors. And one of the most important things that came out of that survey was that if you just ask people to brain dump, they won't tell you everything they know anyway. You have to be able to prompt them with specific things, because nearly everybody would say, oh, I know, these general things. And then you'd ask them a specific, did you hear about X? And they'd be like, oh yeah, I remember that. Oh yeah, I did hear about that. Yeah, I heard about that too. So they have all of this information it's already there. It's ready to be triggered. But the general prompt of tell us everything you know about the case, it doesn't trigger that specific information. So it's a very, very fine line where you need to be able to get the information, but you also can't be suggestive. You can't bring things up to them and potentially taint them with information that they don't already have. So this is already it's already a problematic process just doing this in voir dire. And now to even further limit that, I don't like it at all. I really don't. It's too important a part of the fairness of the trial, knowing if you're going to be able to get an impartial jury or not. And so understanding what they've already been exposed to is really, really important. I pulled up one other thing that I'm going to share just because it came up during Mr. Brennan's argument about the third-party culprit stuff, where he was saying, "Oh, you can't go into reputation for violence and stuff like that. This is all character assassination." Well, here's the thing. Here's the rule on character evidence. There are exceptions in a criminal case. And one of those where the identity of the first aggressor or the first to use deadly force is in dispute, a defendant may offer evidence of specific incidents of violence allegedly initiated by the victim or by a third party acting in concert with or to assist the victim, whether known or unknown to the defendant. Also, the defendant, if the defendant knows about this prior to that, this isn't really necessarily directly on point because that's getting strictly to self-defense. But the identity of the first aggressor, okay? Who started a fight? Is that arguably at issue here? Maybe. I mean, it's not directly on point because, again, that's typically getting into a self-defense type of context. But my point here is mainly that it is far too broad to say, no, you don't get to use character evidence for violence. Yeah, you do. Yeah, you do. When there's violent stuff happening in a case, that can absolutely be relevant and permissible under the rules. So once again, just a little bit of a stretch into the absolutes in his argument from Mr. Brennan. Well, we're still waiting, of course, for an awful lot of these rulings. Last time when we went into the first trial, we never even really got a firm ruling on the third party culprit. We never even really got one. She told him you can't open on it. They haven't even told him that yet, one way or another. She already had that entire first trial. So they should at least know if they can include it in their opening statement or not before they have to give their opening statement. They need to be able to prepare that and accommodate that and decide exactly how they're going to characterize it. I don't expect any substantial difference from how it came out in the first trial. They're clearly allowed to use Bowden. She, made it clear that that's allowed. You can challenge the investigation. The issue is just always going to be arguing these other people did it and how strong you can make that claim, what kind of substantiation there needed to be able to make that claim. Well, we had a whole trial about this, and while she seems to have kind of selective memory of what happened in that first trial, you can treat that whole first trial as an offer of proof. Okay, everybody came in and testified under oath. And so you can rely on that. Plus, now it sounds like these little hints from that motion that the defense might have a little bit more. Very curious about this computer forensic evidence that tends to show that John O'Keefe went into the house. I'm very curious about that. But yeah, I still don't understand. It can't be a third party culprit if John never went inside. I'm sorry. Yeah, you can have a fight. You can have a fight out front. Is there some reason it's not possible to have a fight in the yard? Some reason? I don't know. So the Unsolved production, they want the 200 hours worth of interviews that went into the documentary. I predict they're probably going to get that. I mean, they've been able to get even the off the record stuff, like with Gretchen Voss. Defense, of course, isn't really opposing it. They say it's not really their position to do that. They would argue, just when it comes to admissibility, but not so much with production. So I suspect they will probably get that. If it gives you anything, fine. But it kind of doesn't really make a whole lot of sense, because her whole purpose, as she said in the documentary, in giving this interview, was to be like her testimony. It's for her to put out her version of events. So if you want to take that and give it to the jury as her version of events, okay, that seems like a bit of an own goal, because you're letting her get her story in front of the jury without having to be cross-examined. So I don't think it would be very smart from a strategic standpoint to do that. But hey, if they want to go ahead and do that, try to pick it apart or something like that, I guess they sure can. Privilege was a bridge too far for Judge Cannone. Don't understand exactly why, just that the motion is not appropriate. So again, I think that's a little bit. Karen got kind of lucky with that. Don't ever say the words, "my attorney told me," or "I told my attorney." And then just the questionnaires and the logistics and stuff. I don't really understand their approach to the logistics. I got to be honest with you. So the most common way that I've seen this handled, when you're calling in a great big jury panel and you're doing a questionnaire, you bring everybody in on day one. They complete the questionnaire, and then you send them home. And you start bringing them back the next day. You spend the rest of the day, go ahead and copy the questionnaire, get it distributed to everybody, and then they have some time to review it, because that makes it more efficient when they're going through and doing their questioning. They already know, they've had some time to plan. Here's what we need to ask of these people. Here's what we need to follow up on. If they're just trying to do that on the fly, it's really not very effective. You're trying to thumb through this questionnaire and see what you even need to ask this person. It's time consuming, because I'm going to be sitting there saying, hang on, give me a second here to finish going through this and seeing what they said, instead of just having it laid out ahead of time. So to me, that's what makes a lot more sense. Get them all the questionnaires, then start bringing your people back in, groups the following day. Yeah, we don't want to bring all 150 or 175 or whatever back on the morning of Wednesday, because you're not going to get through all those people. So you just get a reasonable estimate of how many people you can go through in a morning. Can we get through 50 people in a morning? Great. Call the first people back for the morning. Call the second people back, 50 people back for the afternoon. Call the third people back on Thursday. And you do it like that. And so to me, that's pretty straightforward. That's a pretty simple way of doing it. I don't know why we're going to call people in groups and have them do the questionnaires on separate days, and then copy, and while they sit around, they're going to sit around while you're copying. This is not efficient. So surely she's done large jury selection before. She's just talked about this Chisholm case, a lot of publicity there. They're relying on that. They're using the questionnaire as kind of a basis for that. Surely you've done this before and learned from it. I don't know. This doesn't sound like a particularly efficient method to me. Still sorting out what's going on with ARCA, and have they produced, have they not produced? Yes, we don't know what else Mr. Brennan thinks is out there. Mr. Brennan got another report last night from a third dog expert. Is this Garrett Wing? Is this Mr. Wing, or is this somebody else? We now have, for dog experts, we have Dr. Russell. She's the dog bite expert, the medical side. We have Garrett Wing. He's more like Dr. Crosby. He's more of a dog trainer, works with holds and things like that, canine training. Is there a third? Or is he just counting these all collectively? His, including Crosby. That wasn't quite clear, but either way, it sounds like if it's Garrett Wing, maybe Garrett Wing wrote a report. Okay. Yeah, the PowerPoint from Mr. Welcher, it was supposed to be revised, Dr. Welcher, because Mr. Brennan conceded like 3 of the 4 main points that were in his report were not admissible. You don't get to comment on the credibility of witnesses and on who you believe is guilty and which version is true and so on and so forth. You don't get to testify to facts that are outside of your own particular expertise. So Mr. Brennan had conceded all of that was going to be taken out, and yet it's still a 140-page or so PowerPoint. So that does seem like a reasonable assumption to me. Decision on the motion to dismiss and the buffer zone by the end of the day. Well, if we're getting a decision on it, we're clearly not getting an evidentiary hearing on it. And if she knows we're getting the decision by the end of the day while we're talking about the logistics of bringing in a jury, I think we can read the tea leaves on this one that it's not going to be granted. So I don't know if that's any huge surprise to anybody. I don't know if anybody really predicted, as a matter of kind of feasibility, that was going to happen. Just doesn't seem likely. But what I think the real issue here is she going to have the same kind of outrage about the misbehavior of the Commonwealth as she has gone on record already in open court about her view of the conduct of the defense? She has said so many negative things about the defense, all the way back into that first trial when she accused Mr. Yanetti of grandstanding for the cameras. Mr. Yanetti, you need to make your argument to me, not to the cameras, that type of thing. Never called that sort of thing out on the part of the Commonwealth, and as far as I can tell, still hasn't done any of that. But the whole outrage over candor to the tribunal towards the defense over what is kind of a minor statement that, taken in context, is pretty understandable. They're talking about ARCA's formation of their opinions and the fact that the defense did not pay for anything related to that. She's outraged about that. It's misleading. She's got to be able to rely on defense counsel. But when it comes to inverted Sally Port videos and, potentially improper communications behind the scene with witnesses while testimony is ongoing, which came out with the issues relating to Brian Higgins in one of the motions in limine. Mr. Lally met him during lunch, and then after lunch, Mr. Higgins is conceding that he talked about his testimony with Mr. Lally. Not supposed to do that. Is she going to have any outrage about any of that? That's what I want to see. Are they going to be taken to task for any of it? Guess we'll see. And the buffer zone, basically, does it stay 200 feet or does it get extended to 400 feet? I don't know. It's already been upheld by the Supreme Court. They gave their reasoning for that. It's always going to be a little bit risky to impair the First Amendment rights of the public beyond what you already have. So it's not a zero risk proposition. The question is, does she have enough of a record that the jury could potentially be affected by what was going on outside? Being disruptive, is that enough? They hear honks. I don't know if that's enough, because we sure do hear a lot of sirens and stuff going by, don't we? It's just kind of part of what happens when you have a courthouse on a busy street. I think the concern really has to be focused more on content and about, are they aware of who's out there, what they are saying, what they are advocating for, and is that run the risk of imposing some kind of pressure on the jurors in their deliberative process. My gut instinct is she's going to grant it, just because, I mean, even Juror Ronnie said, yeah, we were able to hear it. He suggested it wasn't particularly disruptive other than maybe during lunch, but they weren't deliberating during lunch, so that didn't really matter. But I think she's likely to take the they could hear it and lead that to a conclusion that then therefore there's a risk that they could be exposed to the outside information that that they shouldn't be exposed to. They shouldn't be knowing what's going on with the protests and so forth. So with that, guys, we do have a few questions and comments to go through. Let's go ahead and check that out. Jason McClellan, as a lawyer, how do you deal with bullying from the bench? A magistrate has it in for me. The magistrate claimed that the trial was being delayed due to slow cross-examinations. I was the only one doing cross. It can be really tough. It can be really tough. I can tell you, in my experience, I had one particular judge that I simply stopped appearing in front of. We have a process in Washington where you can, what they call affidavit a judge. You can challenge a judge on the case for any reason or none at all. You don't have to give a reason. You can just basically say, I think this judge won't be fair, and that's it. It's automatic. They get booted. You get reassigned to another judge. So I had a judge where it simply reached the point I would affidavit that judge in any criminal case that I expected was going to be anything other than a rapid and relatively uncontested guilty plea. And even in like a sex case, a guilty plea, nope, not in front of that judge. Nope, he's getting affidavitted. We have that tool, and so that was a power that I had to just be able to minimize that type of opportunity. But of course, I had to learn that the hard way through various appearances in front of this judge. You have to make your record. You have to fight back and stand up for yourself and make it clear why you think what you're doing is appropriate. If cross-examination is slow, maybe it's because there's a lot of questions that need to be asked. And the attorney does get quite a bit of leeway in terms of how am I going to conduct this. Now, if it's like the same question that's being asked and it's being repetitive and there's not really any progress being made, that's a point where you probably are getting into the court's discretion to limit things and require it to be moved along. But if you just have a lot of questions, or if you're kind of systematic in how you ask things piece by piece by piece by piece by piece, you're allowed to do that. So you just got to make your record of why you think the judge is wrong. And, sometimes it may come out that you have to make a record of why you think the judge is unfair. I've had to make that particular comment that, was it Mr. Alessi or Mr. Jackson made the other week in one of these hearings about how, we expect the same treatment when it comes to the Commonwealth's witnesses, the Commonwealth's presentation as is being applied to the defense. Judges don't like when you say that, but sometimes you have to. You got to just call them out on the record. Judge, I expect you to apply this to the Commonwealth, to the state, when it's their turn. I said that in court once. Oh, I got a look. Boy, did I got a real look from the court. Very, very offended that I would say something like that. But if it's happening, you got to call it out. It's part of the job. It's the courtroom is not a place for shrinking violets. You got to be willing to be assertive. So the reality is just that some judges do behave like this. They are kind of bullies. They do try to push you around. And part of that is because they're seeing if they can get away with it. So if they can't get away with it, and you stand up for yourself and you call them out and you make your record, sometimes they'll back off from doing that. Stephanie H., thank you for your coverage, Andrea. Appreciate your insight and knowledge on these cases that can be hard to make sense of. Well, thank you very much. Appreciate you being here, and just glad I can share what I've picked up over the years and kind of what I've learned through this process and all the legal minutia that's taken up all of the free space in my brain that could be focused on other things, but isn't. Michael Muddragon, everyone testifying the time Colin left is sus. Well, and the whole manner of how they did that is pretty sus too, right? Colin doesn't remember anything at all except the exact time that he left and the exact time that he got home and the exact number of stairs that he went up when it was time to kiss the parents goodnight. They don't know what time anything else happened. Time is an immaterial construct. Time? What is time? I don't know this word, but Colin definitely left at exactly 12:10. And it's such a precise time. That's part of what's so sus about it. Everything else is vague, vague. Oh, well, it was around this or about that. But Colin, it's 12:10. That is very precise. Wouldn't most people, if you were ballparking, you'd say like quarter after? Maybe 12, maybe 12:15. You tend to think in certain kind of manageable increments. And I don't, 12:10, that just seems unusual to me. It doesn't seem like what is going to immediately come to the top of your brain if you're trying to think it up. And then the other piece in all of this too, that makes it sus, everybody's been drinking. Everybody has been drinking this night. And so that tends to make things a little bit more fuzzy. You don't necessarily remember exactly how time is moving and how events are relating to each other. Things get fuzzy, but yet there's this very, very sharp 12:10. I agree. I think to me, it's also a little bit sus that they have that nailed down so specifically. Beagle Mom, it's not a good day in court without Andrea's commentary. I swear I love it. Well, thank you very much. I appreciate being able to add what I have to add. Duncan, Idaho, just tell them the guy never went in the house. Yeah, there's your no proof of a cover-up, Mr. Brennan. Absolutely no evidence of a cover-up. Well, what about this one? Just tell them the guy never went in the house. Why would we all need to be getting on the same page about whether or not John went into the house? If that's in fact what happened, you wouldn't need that instruction if that's what happened. This is definitely sus. It looks like part of the cover-up. It looks like part of getting the story straight. And then that whole the guy. Doesn't that remind you of Jim McCabe's 911 call? There's a man in the snow. Doesn't mention who he is, the fact that she knows who he is, the fact that he was supposed to be coming to the party where she was at that night. Just, there's a man in the snow, unconscious. Very, very distancing. Duncan, Idaho, I was bit on the leg by a dog when was a mailman. The marks looked exactly the same as John O'Keefe's arm marks. Never been mauled by an SUV though, so who knows? Yeah, if the SUV really gets you in those gripping teeth, and if it gives you a little shake, that might get you a little bit of a similar pattern. I think that's an important question for the accident reconstructionist. Did the tail light, did it shake once it had that firm grip on the arm? Did it shake it at all? And then it got out. I don't know. Yeah, I mean, they look like dog bite marks. We've just seen so many examples now of dog bite marks. I'm also looking forward to the Dr. Russell reprise because she's had so much more time now to potentially be able to add to, substantiate, support her opinion. Yeah, you could have photos, you could have demonstratives, you could have charts, you could show like, here's all these other cases of dog bites. These are what I'm basing my opinion on. You can typically do stuff like that. So would be kind of cool to see something like that, just to hammer home that, guys, we're not idiots. This was not caused by a tail light. These have got punctures and stuff. This was a dog. Melissa Dobson, Andy Cops's bingo bonus word for the day, ass sliding. Yeah, that's that is the strategy of Mr. Brennan, isn't it? It's the gaslighting in a particularly obnoxious way. Particularly obnoxious. There's absolutely no evidence. Well, except for that part where they're texting each other. Just tell them the guy never came inside. Stuff like that. Yeah. The dash in between with Matt Bond. Cue look squirrel argument. Yeah, well, when Mr. Brennan doesn't want you to be looking at the evidence, he's just telling you there's no evidence, right? There's no evidence. And what the defense didn't tell you, he never actually really came back to that, did he? He said, well, I'm going to talk about the case law and not about what they didn't say. But then he really didn't do that. He really didn't do that. He talked about the couple of cases, this campsite case where they didn't let in pure hearsay just because I guess somebody was at a campsite. Pure hearsay about his violent past or something. I don't know. It did not sound like a very similar case from a fact standpoint. This is not a random campsite that Brian Albert, Brian Higgins, and Colin Albert were at. It was Brian Albert's home. Kind of different. And we're not trying to get hearsay in either. It sounds like, according to Mr. Yanetti, they have the actual cops who had been sucker punched by Brian Albert while he was drunk, who are prepared to come in and testify their personal experience, not hearsay, that, oh yeah, he was a mean drunk and this is what he did to me. Kind of a little bit of a different fact scenario. Otherwise, yeah, he just hammers on, no, there's no proof John O'Keefe was in the house. It's circumstantial evidence. And yes, he finally has to acknowledge, yeah, you can infer certain facts. He's talking about, what was he talking about at that point? The cell phone, the SIM card and the cell phone in the dumpster. Yeah, you can infer that looks bad. Yeah, you can. Yes, you can. And everybody does, and everybody will. You know that. But that's not the only thing you can infer facts from. You can infer facts from all of the circumstantial evidence. And so, yeah, when there's circumstantial evidence that John went in the house because his phone says he went up 2 flights of stairs at the right time, when he was, otherwise not supposed to be anywhere near stairs. There's no stairs in this yard. Yeah, they can infer that he went inside. They can infer it from the timing of when he was dropped off and when Karen arrived back home, etc. They can infer that. So, yeah, look, squirrel. Don't look at the evidence. We'll just keep insisting there is none. And look at this case law over here that looks nothing like the situation. Pay attention to that. Kind of classic Brennan argument there. Duncan, Idaho, really unexpected she ruled against the Commonwealth. That's a pleasant surprise. I do wish she had allowed Alessi to finish cooking, though. Yeah, she just went ahead and put the stop to that. Not necessary. You know what? We get it. Why? I do wonder if Mr. Alessi was going to go down that rabbit hole of what's their good faith belief that there's anything in those texts, because there shouldn't be anything in those texts. According to their own version of events, they should know there wouldn't be any communications there for that 3-day period because the communications would have stopped the afternoon of January the 29th. So I'm pleased to see it in part because this seems to be a nice shift from her previous perspective in the first trial about your right to counsel and that relationship and all that, when the Commonwealth, still one of my biggest beefs here, is trying to argue the fact that she called a defense lawyer is evidence of guilt, consciousness of guilt. And instead of laughing them out of the courtroom and sending them back for remedial constitutional training, she complimented them on their argument. I'm going to compliment you on your argument, but I'm going to deny it. Glad she's moved off from that. Maybe it wasn't so smart to compliment that argument that never should have been made, because maybe that's the kind of thing that opened the door to this sort of thing being brought up. Yeah, it would have been nice to hear what else Mr. Alessi had to say. So, Mark Davis. So if I'm pulled over and tell a cop, I've been advised by my attorney not to answer questions, that's technically a waiver. That is invoking your rights. That is protecting your privilege. As long as you follow the attorney's advice not to answer the questions, this is protecting your privilege. This is not waiving your privilege. Now, is the attorney potentially going to be willing to confirm? Yes, I gave that advice. Maybe. But the whole my attorney told me not to talk or my attorney told me not to answer questions, that's protecting your privilege. You just need to follow the advice now. Everage, this judge confuses me so much. Yeah, she's very, very inconsistent and unpredictable. I'm pleasantly surprised. I really am very pleasantly surprised that she's not going to open that door. I really did. And the main reason that I can see why she would not, again, just be gleeful at the opportunity to take Mr. Yanetti down a peg, take Mr. Jackson down a peg, and just have the whole I told you so about the pretrial publicity. The only reason why is because she just seems very adamant about getting this trial started right now. She doesn't want it to delay anymore. I don't really understand that. Like, granted, I'm not a judge. I don't have their schedule to maintain. I don't know what else is on her docket that she's maybe contemplating. But that's the main reason I can think of, is she just sees this might open a door and that's going to cause delay. There's a lot of reasons to think it's inappropriate. The timing is a huge one. The Commonwealth's already filed their certificate of compliance, and now they want to reopen this part of the investigation a week before trial on something that's been out there. I mean, they said, Mr. Alessi said 9 months. If it was 2023 that she did the interview, that's well over a year ago. That's almost 2 years ago. If that was a typo and it was 2024, then okay, it's just under a year ago. So yeah, it's been out there a long time, and it's the same thing. The Gretchen Voss statement is the same thing that she said in the recent documentary. So that's a perfectly good reason to say, no, it's inappropriate. You could have followed up on this a long time ago. And so to wait until the eve of trial, that's the reason why I'm not going to let you do it. Not because, I think you should, or I think you shouldn't be able to, or I think this is an intrusive ask. She's not going to give us that clarity in her reasoning, which is a little bit unfortunate, because I would like to know, if she thinks this is a bridge too far as intrusiveness, that would improve my opinion of Judge Cannone. It really would, seeing that, yeah, the Commonwealth can go too far. Micheline McWilliams, happy birthday. Have a great day. Thank you so much. Very kind of you. It's tomorrow. My birthday is tomorrow. Today's my birthday eve. Of course, at my age, you don't necessarily don't necessarily celebrate like you did when you were younger. Sometimes might prefer they just pass unnoticed. We can all forget it happens. No, I'm just kidding. It's not that big a deal. You know, you reach a certain point and doesn't matter. You know, age is age, and each year is kind of a blessing because I had a moment after I turned 40 where it's really hard to describe, but it literally felt like if you have an hourglass, you know, and the sand has all been going that way. It literally felt like in a moment, like the hourglass shifted and the time started running the other way. And it was just the sense of, you know, when you're young and you have your whole life ahead of you and you're in this kind of growth period of your life, you know, and you get to the end of that where you don't have that time, you don't have the growth, you start being constrained by your past. You know, your opportunities are not wide open before you. You've already gotten to a certain point because of those choices you made before. Just a real shift in perspective that I did. It like happened in a moment, and that's really stuck with me. So it is a different phase in life for sure. But I'm there. That's it. So it doesn't matter, you know, what the number is and stuff. I'll be 47, guys. I'll go ahead and just put that out there. Flummoxed Alessi. If she doesn't mention an evidentiary hearing in her ruling, can the defense ask for it again next week to be done in drips and drabs while impaneling the jury? They can always move for reconsideration, and yeah, they could ask for it. Will she give it to him? Honestly, I doubt it. She's not going to likely assume that there would be time while they're doing the impaneling, and the reality is there probably wouldn't. It always takes longer than you think it's going to. You know, if you bring people in, like say we do it the way I suggested, you send them all home after they do the questionnaire, you bring the first 50 back in the morning on Wednesday. What's always going to happen is you make it through 35 people, you know, and then you get backed up. So I don't think she's likely to assume that they will have extra time during the jury selection process. Maybe she'll just say cross-examine them on it, you know, bring it out during the cross-examination. I don't know. But I just think if she hasn't already gone down that road, it's unlikely that she would. Now, I suppose it's possible her ruling could be we need to have an evidentiary hearing, and so we're going to do that at some point, you know, while the trial is underway. Maybe that whole thing she suggested in the with respect to the stay and the continuing the trial, maybe we'll just select the jurors but not swear them, not start the jury. You can always too. You can swear them in and then just tell them, come back in 2 days or 3 days or something like that. We're not necessarily going to start immediately. Take the time to do the hearing. So I suppose that's possible. It's possible that her ruling that we get today could just be it's necessary to have an evidentiary hearing. I just doubt it though, because she described it as a decision. So it sounds like she has made up her mind whether or not she is going to dismiss the case. Z is no evidentiary hearing on motion to dismiss, strong on appeal. It's discretionary. And so it's one of these issues that just kind of depends on what she decides and how. If she decides it on the basis of factual issues, you know, the defense is wrong, this is not what happened, something else happened, that's potentially a strong appeal issue because you don't have a record. You didn't get these people under oath to establish what did or didn't happen. So you don't really have anything to rely on. This is the petard that she used with the defense on that motion for the forensically sound, you know, image of the Sallyport video. Deny it because they didn't submit an affidavit. There's nothing for her to rely on. Yeah, that is the rule. You need to have affidavits. Brennan didn't submit affidavits. They submitted that one, signed by the 3 attorneys kind of general affidavit, but that just describes their part. They don't have personal knowledge of what was going on in the Sally Port, what was going on with the video production and so forth. So that, is potentially a strong issue if she's making factual findings that she doesn't have a record to be able to substantiate. But what I think is more likely is that she would do something like say, even if all of this is true, dismissal isn't the appropriate remedy. She has a lot of discretion in deciding what's an appropriate remedy in the case. You're really going to be on the back foot on appeal, arguing that dismissal is the only way that you can adequately respond to this. So that's what I would anticipate. It's likely going to be, and if it is that is much, much harder to challenge on appeal. And it doesn't really have anything to do with the evidentiary hearing or not, because she's basically saying, even if everything the defense says is true, I don't think dismissal is the way to handle it. Zencat, happy BJ. Do you think Bev wants this trial done before the Birchmore trial starts? Date TBD. Well, I think that's inevitable. It's definitely going to happen before the Birchmore trial starts, at least at this point, because the Birchmore trial has a long way to go. They just keep kicking that one kind of down the road. It is, of course, a death penalty case in the federal court. So you can just expect automatically that's going to make it take a lot longer. There's probably going to be a lot of pretrial litigation that we really haven't seen yet, because a lot of that stuff just takes time. So, I don't think that's probably specifically it. Now, it could be that the longer time goes on, the more information comes out in the context of the Birchmore trial, the more we see about what was done, who did it, investigation, and so forth. We already know quite a bit about the overlap, Fanning's involvement, Lank's involvement, Guarino's involvement. Guarino's involvement is a big one. 35,000 text messages that he somehow just didn't see between Matt Farwell and Sandra Birchmore. That's another motion in this case we're still waiting for a ruling on, right? Are they going to be able to bring any of that up? That, to me, that's fair game. That should be fair game. It should be fair game, because that goes to a pattern of unreliability in your work, the exact type of work that you did in this case. You overlook things that aren't convenient when it comes to, is a law enforcement officer potentially responsible, potentially criminally culpable? Really tends to support that framed theory, doesn't it? That Brian Albert was never going to be investigated as a serious suspect. Nothing to see here. So I could see something like that coming into play. I could also see the whole issue with the what's the word I'm looking for? The audit of the Canton Police Department that's been ongoing. I could see it having to do with that. She doesn't want to open the door for all of the shortcomings of the policing there to now, be relevant in this particular trial. So that's another possibility of a reason to try to get it going ASAP. But honestly, guys, I really just kind of think it has to do with summer. I really do. And I know, I think she has her schedule, the way that she likes to live her life, and she likes to plan things around that, and she doesn't want it interfered with. She wants to spend her summer at the beach house. That's what I think. Mark Davis, no way you're 47. Well, you're too kind. So is it generally considered an exception if you quote your attorney giving general advice like be quiet and not a waiver to the entire conversation? Thanks. Here's how to look at it. Yes, technically this is a waiver, but what is the waiver? What's the scope of the waiver? That's always a very important question when you're talking about an attorney client privilege situation. Waiver does tend to get construed narrowly, but if you are, intentionally and knowingly disclosing this conversation, that's a waiver. There's an argument it extends to the subject matter of that communication. What's the subject matter of this communication? Your attorney telling you to shut up. So the conversation about your attorney telling you to shut up, maybe that's waived, that particular piece of advice. It's pretty limited, right? It's pretty limited. Like maybe it opens the door to be able to ask your attorney, did you tell so-and-so to shut up? Yeah, I did. End of story. The reason why I think it could have been more problematic in Karen's situation is because it wasn't this limited. It wasn't just my attorney told me this. It was describing a conversation and the advice she was giving as a result of that conversation, and the fact that because of that conversation, that was the impression that she had, for about 3 days. What happened after 3 days? I'm not quite sure. I think that's when they're saying they got the tip. David Yanetti's office got the tip, where somebody said, you need to look at the homeowner. He got beat up inside the house. Something like that. That, I guess, is the 3 days. But it's just not entirely clear. So the risk is just that the more you say, the more you broaden the scope of what are you talking about. You're potentially opening up more of the subject matter of the conversation to the argument that it's been waived. So something like this, yeah, you might technically consider that a waiver, but it's just so limited that it's very unlikely to be problematic. And again, because it is for that purpose of protecting your privilege. Shut up. Shut up. Just don't say, so follow the advice and you'll be good to go. Well, guys, looks like that's everything for today. We got no future hearings on the horizon until April 1st when we get started. So here's kind of what I'm thinking. Of course, they don't televise jury selection. So while that's going on, we're really not going to see anything. But I think, going to plan on being ready to stream on the 1st when they start the jury selection. Because one, there are some loose ends, like she keeps pointing out. I want to see if we get any of these loose ends addressed. That does need to be done in open court. And so, I would expect that to be televised. If it's not, then I'll just cancel it. But I would expect that to be. There's that whole charging instruction, the initial instructions that she gives the panel when they come in. That's also, typically done in open court. So I'm going to go ahead and plan to be watching on the 1st, and we'll just see what we get. I'm expecting, like I said, there won't be much televised while they're actually in, the process of questioning the jurors and getting the jury selected. But we really don't know how long that's going to be. And then if there are rulings in the meantime, maybe they'll be on camera, maybe they won't. I just don't know. We're going to have to play it a little bit by ear. But then, of course, once they have the jury picked and we're going to be back for either some rulings or for the openings, then we'll plan to go ahead and be ready to go live for that as well. So other thing I wanted to mention, next week, we're going to have a little bit of a scheduling conflict, and I still have not quite sorted out how I'm going to do this, because I'm going to have to pick one or the other and then catch up catch up on the one I can't look at. We got the motion and limine hearings in Brian Koberger's case next week on, I believe it's the 9th and into the 10th if necessary. There have been a lot of motions filed. I have been working on getting caught up on all that. Then, of course, replies were due yesterday. So I'm like back behind the 8 ball, trying to get through all that material. I am planning on trying to get a couple of videos out before we have those hearings on the motions in limine, just to kind of go over the ones that stand out, what the positions on them are, and kind of what my expectation is going to be for those. So that, is something that you can look forward to. But in the meantime, how's that going to work? How's that going to work with that hearing is going on while Karen Reed is also going on? We should be into trial at that point if we don't do what Judge Bev suggested and just wait to bring the jury in. Chances are I'm going to go ahead and just stick with Karen Reed and catch up with Brian Koberger when we get a break, maybe over the weekend. So could be a little bit of a busy week next week, but I did want to just put that out there for you guys that I do plan on paying attention to both of those. It is a lot going on. And a lot of you have been very, very patient waiting for me to get back to you on Koberger stuff, because the motions in limine did start coming in while I was out of the country. And it's just been a process of catching up since then. Also have something coming out probably tomorrow, maybe later this evening. Haven't quite figured that out yet, but I've been promising you guys my take on Juror Ronnie's interview. So I did talk a little bit about that today, but I made a video where I kind of went over what were some of the big takeaways that I had from it. I'm very busy and behind right now, and so I have a lot of things going on, and so I multitasked with this video. I thought maybe you guys would like to see me talk while I am repotting one of my bonsai trees. I got a lot of repotting to do. Way behind. It's very late in the season. So if that sounds like the kind of thing you might enjoy, it's very casual. I am in my grubby clothes. I'm pretty sure I'm covered in water because, you get wet dealing with the bonsai trees. It's just going to be a little bit of a light conversation, but that should be coming out shortly, and give you my thoughts about that juror interview and kind of what some of my takeaways were. So that's what's on the horizon, guys. It's been fun, been a fun one. Thank you to everybody in the chat. Once again, thank you for joining us, and thank you for all of your great questions and conversations, all the fun. You're so clever. You guys have so many clever quips and stuff like that. I always like when we're in hearings, because I do get a little bit more of an opportunity to kind of look over and see what's happening. When I'm talking, I can't talk and read at the same time. Honestly, guys, to be honest, it's a little bit hard for me to talk and repot a bonsai at the same time. I chose a very easy tree, because there are certain points in the process where you have to really think about what you're doing. And if I had one of my more complicated trees, I would have to be like, hang on, let me figure out this puzzle here. And then I'll go back to whatever my train of thought was on the case. So that can be a bit of a challenge, but when the court's going, I can listen and read a little bit better. So always love to be able to peek over at your clever comments and questions and everything. So thank you all for that, for being a part of it and making this a fun place to hang and see what's going to happen next. See how this is going to unfold. I am getting excited about the reprise. I am. It's like the first trial was just a dress rehearsal. And now we get the real deal. Now we get to see how they learn and how they shift and what they've added. A lot of forensic stuff we know they've added. Seen some other lay witnesses that they've added. I'm very, very curious to see how this unfolds. So with that, guys, Looks like one more question has come in from Everage. Also, if Yanetti is conflicted off, would that not put the rest of the team at risk because they are out-of-town lawyers and he is the in-town lawyer? Yeah, I mean, it's possible that they could just get another local attorney to sponsor them. When you're pro hac vice, you have to have a local attorney licensed in that jurisdiction that will sponsor you. So it's possible that they could do that. It's not that uncommon for local counsel to not necessarily be that in on the details of the case. This was something that I did a little bit of when I was in private practice. When you're in a small community, you got cases that involve, attorneys from Seattle, attorneys from Portland, things like that. They don't want to necessarily come down to have to appear in court on preliminary unimportant things. So they hire a local attorney to be able to do that, but they do all of the filings and all the research and stuff. It's really their case. You're just kind of there to, give voice to their arguments. So your input into that is pretty small. That's not particularly uncommon. Of course, it's a little bit different with the pro hac vice situation because they have to be responsible for the other lawyers. But that doesn't necessarily entail knowing the case, knowing the facts, knowing the evidence, all that stuff. It just means you're going to be the one that's in charge if people are breaking the rules and stuff. So you got to make sure that they're on top of the rules. So theoretically that could be curable, but it's something that they'd have to figure out. Yeah. And it's something they'd have to scramble to figure out. Could definitely be an issue. The whole other problem there too, if this is a waiver and like the Gretchen Voss interview, if Mr. Jackson and Ms. Little were present there as well, another potential conflict situation, if they want to fish into potential impeachment there. So, yeah. I think it's likely that is why Judge Cannone doesn't want to go down that road. Is just the door that it could potentially open could be very, very disruptive, and it's very high risk for her. It's very high risk. Karen has the right to constitutional right to a defense, and even though privilege in and of itself isn't a constitutional issue, it's a creation of common law and statute. Nevertheless, it crosses into that arena. It's very closely related. Like there have been cases where, for example, police listen in on the phone calls, like from the jail. We've had issues all over the country. We had issues in my state because they use the different telephone systems for jail that are out there. There's GTL, there's Securus, there's kind of these common ones, these providers, and they're supposed to all have these systems where the attorneys are kind of screened off. And so the attorney-client phone calls are not recorded and they're not listened to, but that doesn't always happen. It hasn't always been the case. And so there have been situations where law enforcement or the prosecutors have gotten busted listening to attorney-client conversations. And there's good case law on that is an impairment of the constitutional right to counsel. You're not basically you can't freely exercise your right to counsel if they're listening in and they're breaching that confidentiality. So there is enough of an overlap there that it's a risky area for her to be saying, Sure, go ahead and look at her text messages with Mr. Yanetti. She has erred on the side of being conservative about that, and that even if I didn't think that was necessarily what she's going to do, it probably is the smarter approach. So, all right, guys, with that, thank you once again for being here. Keep an eye out on a couple things that hopefully will be forthcoming soon. I am leaving town for my birthday. I'm very excited about that. So that's why I'm saying probably tomorrow, keep an eye out for the one about the Juror Ronnie interview that Dr. Turtleboy did. And then I won't be back until early part of next week. So probably just in time to get started here on day 1 of the trial. So guys, hang tight. We're almost there, about to get started, barring any kind of last minute change, which in this case, of course, we can never really rule out. But it's looking pretty positive for all systems go on April the 1st. So I will plan to be here. We'll probably have, like she said, some decisions that we can talk about while we're waiting for them to get started, and see where we're at with the rest of the loose ends. And we'll get ready for the reprise, the tune-up. Yeah, looking forward to it. Thank you, everybody, and we'll see you on Tuesday.